Good morning, good evening, good afternoon. Let's see what we got going on here. All right. All right. So it appears to be up and running. So, yeah. So the plan is that I'm going to watch some of these Lane Meyer hearings to see, what's going on. Today is a holiday, the court holiday. They don't give us Easter off, but they do give us Cesar Chavez Day because apparently the religion of communism is more important to California than the religion of Christianity, including Protestantism, Catholicism, Eastern Orthodox, etc., etc. So we're going to start off with this is the November 15th hearing. Good morning, tomatoes or tomatoes. Dole want to talk with a troll? Dole? Do I? Do I want to talk with the troll? Do I want to talk with the troll? Not particularly, but you know. Oh yeah, so I do have a link pinned. DSOI, how drunk are you, Tomato? Um, so there is a link posted. There, it's pinned. So if you do want to come up and talk, if somebody does want to come up and talk, then I am then I'm willing to talk. I mean, there's a lot of people who have a lot to say, and on my Lane Myers videos, and so sure, maybe Easter is not quote holiday end quote because it's on a Sunday already. Yeah, just like every other Sunday holiday that goes on to a weekday. Normally, if things like if Christmas, for example, falls on a Saturday or Sunday, you get the corresponding Monday off. So good morning to you, Melanie. All right, well let's get this party started, shall we?
Are you saying use that, ma'am? 5 minutes. Ma'am, are you saying to use that?
Well, that's the plug.
Oh, okay. I see what you're saying. You brought it up higher.
Hold on a second. I've actually seen this where it was the actual recording from the court. Where did I see that? Was that maybe that was a video, not a live? Maybe that was a video and not the live. It would have been about 4 months ago. The version that I watched of the November 15th hearing was filmed by the court. Does somebody have a link to the November 15th one that I watched that was filmed by the court and wasn't a pocket recording? You tell I watch a bunch of his stuff. I'm not really interested in him as a person. I'm interested in him as a pro se attorney. Was it alive? Was it alive? Checking to see. You think it's this one? Okay. I don't know what you mean by this one. Don't know what you mean by this one. I don't know what you mean by this one. That was the pocket one. All right, we're checking in. Captain Kangaroo hops off his rocker. Public hero. Captain Kangaroo hops off his rocker. Public hero. Captain Kangaroo hops off his rocker.
One thing.
That is it. Oh, we found it. You guys rock. I don't care what people say about you. I don't care what people say about you. All right. So we found it. Thank you to Lucid's Lair. All right. Is that? Oh, it was on somebody else's channel. All righty. Well, let's do this.
I mean, if you can, you know.
Let me know when you're ready.
This is a public service.
I just want to say how absurd it is. His entire setup thing with his computer and his moving stuff around. It is absurd. It is distracting. You don't see real attorneys doing this kind of stuff. So yeah.
I was ready in October of 1982.
Wonka wonka. Ready in October of 82. I believe him.
Are you ready, Mr. Myers? All right, you gave me the thumbs up.
Yes, sir. Yes, Your Honor, I'm ready.
So, Mr. Myers, the way it works is I listen to everybody. When someone makes an objection, I listen to them. Then I'll give you a chance to respond, and then I'll rule on the objection.
Thank you.
And we just need to take turns talking, and I get to control that since I'm the judge.
By the way, I do want to apologize. I had stated that the alleged victim over here, Miss Walker, I had stated that she was an attorney, and I was disappointed in her performance as an attorney. She is, however, not an attorney. So there you go. Just reset yourself that she is not an attorney. She is a layperson who happens to work in an administrative role at a law school, at a law university, a university of law. So, and as a layperson, as an administrator in the law school, she would have no greater or lesser understanding of the law or how to do anything than anybody else would, except she is, let's see, she is educated. So she graduated from the University of Arizona with dual bachelor's degrees in psychology and sociology in 2013. Well, we do this. So it's right in here. She graduated from the University of Arizona with dual bachelor's degree in psychology and sociology in 2013. She earned a Master of Public Education from Arizona State University in 2021, and she's currently a PhD candidate in higher education at the University of Arizona. Nowhere in there does it suggest, state, or otherwise imply that she is an attorney, that she has gone to law school, graduated from law school, and or taken the bar, and or done anything else necessary to be an attorney. So I just want to clarify that I was wrong. She's not an attorney. She's never been an attorney, and I should not hold her to the standard of an attorney. And in response to Tomato's suggestion that about wearing a tie like that in court, no, I would be respectful to the court. Her husband, Matthew, the Tucson City prosecutor, is in the blue shirt, black tie, glasses. Blue shirt, black tie, glasses. This guy right here, well, it is an open courtroom and he is allowed to be present. My assumption is that one of these two ladies right here, I think it's this one at the far end. My assumption is that is Lane Meyer's girlfriend or wife, or who knows. I love all the comments that I got about how well, they could be common law married or whatever. Just for the record, Arizona does not recognize common law marriages unless you come from a jurisdiction where you qualified for common law marriage in that jurisdiction and then moved to Arizona. So if you were common law married in, like, I don't know, Missouri, and then you moved to Arizona, not that I necessarily know if Missouri recognizes common law marriage, but you get my point. If you were technically legally, let's say, I know Georgia's, I have a case where parties were divorced in Georgia, and then they stayed there for some time, divorced, and then they moved to California, and now wife is suing husband for a divorce in California. And I did have to look up Georgia to see if Georgia recognized common law marriage and what their particular rules on it were. So if someone moved from Georgia to Arizona and they were common law married in Georgia, then Arizona would recognize Georgia's common law marriage. But you can't get common law married in Arizona. And my understanding of this whole thing between Lane and his girlfriend, wife, or whatever, is that she has always been a resident of Arizona, or at least since 2018 when she went to school there, when she was going to school in Arizona. And Lane Myers moved to Arizona to get with it. Waka waka.
So Ms. Walker, you were making an objection. Are you done with your objection?
Now, this is probably a tongue-in-cheek comment from Joe. Looking pretty gay, Joe. Gotta say, you're looking pretty gay there, brother. Not that there's anything wrong with that, but no. So again, I don't know if you've missed my prior videos, but it is not the act of what you do. It's the intention behind what you're doing that's going to be presumptively the problem. The state would have to show your mental state, your mens rea, in order for it to become an issue. So I am not putting out anything. I don't know if you maybe have been cognizant of this, but I try not to say the alleged victim's name. I have not shown any image of her other than this from a public proceeding where, the state of Arizona decided to film it. So, kinda, yeah. I mean, look at the pose, bro. Like, I'm sorry, look at the pose. I'm not saying you're gay. I'm just saying, well, you're comfortable with your sexuality. Funny how you never play the hearing with Matthew Walker. I don't care about the hearing with Matthew Walker. That's why I don't. And this is a hearing where he's representing himself. This is the start of the current saga that I do care about. And the court finds that she is, in fact, a victim. So I hate to break this to you, but your particular subjective interpretation of whether or not she's a victim is completely immaterial and irrelevant. The court's determination, you wonder why. So here's why. It's because that case was dismissed by the prosecutor. That's why. It was dismissed by the prosecutor. There was no finding of fact by the judge. If Lane had been convicted, then sure. I mean, if he was pro per, and he defended himself and he got convicted, I might be interested in it. I mean, I am interested in these things, and I look at them, and you'll see I've critiqued the alleged victim here, her performance, and I've also critiqued the judge's performance here, and I think there are grounds for an appeal if Lane Myers hasn't effed himself in the a-hole by his actions here in court at the end. So I do try to look at these things fairly, and if there was unequal enforcement, that might be grounds for a lawsuit or for a defense. But I'm not interested in it because there's no resolution there, and it's been dismissed without prejudice. So I'm not interested in it. And unless someone can get me the documents where I can see what's going on and put everything into context. I mean, so contempt of cop, if you get me the charging documents and the motion documents and the appeal documents, I'll go through them. I don't have any issues doing that. I would actually love to go through all that stuff. It is a Monday, so I might get clients contacting me or something. And if I do, I'll have to excuse myself. So I apologize. Most people don't recognize that it's Cesar Chavez Day and the courts are closed. So there you go. All right.
That's helpful, but I think I got through about half of it. But the two main points are that by Mr. Myers live streaming right now, it's actually part of what has caused so much harassment for me, as well as others.
God bless you. So procedurally, to get to this point, the alleged victim would have had to file moving paperwork. I believe it would be a petition. It might be a complaint. Not entirely sure. Don't really care. Same difference. My understanding is there already would have been an ex parte hearing. What that means is it would have been a hearing where she would present evidence to the court without Lane Myers present. And she would bear the burden of proving beyond a, I assume it'd be, so in California for civil harassment, it's clear and convincing. But for the initial one, the temporary one, then that is just a probable cause. Essentially, it's a very low burden on the ex parte state. But in California, it's just done on the moving paperwork. There's no hearing. My understanding is then after she does that, if the court grants the ex parte restraining order, then the restrained party, I don't know if he's a respondent or defendant, again, same difference, has the opportunity to request a hearing. And then it is a trial. It is a hearing where evidence is presented and witnesses are examined. And at that point, then the burden is still on her, the plaintiff. I think it says plaintiff there. Yeah, it says plaintiff. So I guess they call it the plaintiff. So the burden would be on the plaintiff at that point to prove, I believe by preponderance of the evidence, but I could be wrong about that, the level of proof required. Again, California is clear and convincing. I don't know about Arizona. But the burden of proof is on her to show that he's actually harassing her. A contempt of cop who apparently doesn't trust my legal judgment is asking me legal questions. So let's dive in. Is it legal for a judge to change the terms of an injunction on the spot without having to file for a completely different injunction? Well, so there's a lot of loaded language in there. So it's hard for me to say whether or not what's going on here. I don't know what you mean by completely different injunction. Can the judge change the terms of an injunction on the spot? Absolutely, especially if both parties are present. Can a judge change it completely? Like if the plaintiff asked for an injunction against him building his business, and at the hearing instead, the judge can't issue, for example, a civil harassment restraining order, because those are two different things, two different injunctions. So when you say completely different, I don't know. The problem with a lot of pro se people, especially people who believe they understand the law, is that they misuse words, and they don't, like they throw out hypotheticals, and they don't understand how many things are missing in order for me to appropriately analyze it, which is generally speaking why I like to do things like use hearings. For example, in this hearing, I get to look at the evidence that was presented to the judge, and I get to make my determination based on the evidence that I see presented. Now, all the discussion about evidence presented outside of court is meaningless because it was not in court. If it doesn't get in front of the judge, it doesn't count. So when people like to talk about things like, oh, you don't know all the background, all the backstory, you need to know all the story to really understand it. No, I don't. Because it wasn't presented in front of the judge. It didn't make it in front of the judge. Lane Myers is completely incompetent at getting his story in front of the judge. So both parties were not present. I don't know what you. So if she's asking for an injunction against him, and she gets in front of the court, then the judge could modify what. Like he could give her some, all, or a different thing of what she's asking for. For example, if the judge might tailor things to like comply with First Amendment, if he thinks that he needs to do things that comply with, you know what I'm saying? Like, so it depends. You really have to give me specifics. Then they hid the hearing. Like, bro, like you're just being fucking weird. Just stop. Generally speaking, yes, a judge can modify the terms of a injunction. Generally speaking, yes. So there you go.
Do you need tissue?
I listen.
Thank you.
So I do believe that that is a violation of the injunction as it's written.
Thank you. Mr. Myers, are you broadcasting what you're recording right now?
122H of the Arizona Rules of Procedure.
Mr. Myers, just answer my question. Are you
Yes,
broadcasting?
I am. And I'm allowed to.
And that's your reading of the rule?
Absolutely. And we can, if we want to argue it, we should do it in a contempt hearing after, not in the middle of my injunction hearing.
I believe that the what he's citing there allows him to record. It allows him to have a recording device on his person. I don't know that it allows him to actually broadcast it, but I don't know that I don't know that there's really a difference enough for anybody to care between him recording it and then posting it later, or him broadcasting it live. But again, I don't think anybody really cares. I don't think it makes a big enough difference to matter.
Anything else you want to say?
Me? Yeah, absolutely. If you're saying directly the response to that, right?
The objection?
Yeah, that's, reply to her.
Anything else?
No, I'm saying I want to reply to her objection. Is that what you're asking me? Yes, I do. I want to, the reason, and I've verified this with the Supreme Court multiple different times. The reason 122H exists, I
He doesn't even have his shirt tucked in. Lord have mercy.
can literally walk in here without, I did you a favor and notified you ahead of time today.
I believe you have to notify the court that you will be recording. So I believe you have to notify the court, and the court can, for good cause, deny you the right to record. Courts have inherent control over their courtroom. That's Pima County's interpretation of Rule 122. There we go. Here's Westlaw's. All right. So this H allows for personal audio recorders. Required notice to the court. A person may use a personal audio recorder during a proceeding, but the person must notify the judge or the judge's staff prior to using the device. In other words, before you start recording, you have to notify the judge or the judge's staff. A person who uses a personal recorder is not required to submit a request under paragraph C of this rule, but a person who wishes to record or broadcast the audio portion of a proceeding with a device that is not on the person must do so. The use of a personal audio recorder must not be obtrusive, distracting, or otherwise prohibited. See this part, or otherwise prohibited? And the use is subject to the prohibitions of paragraph K of this rule. What is paragraph K? A person is not allowed to permit, under certain circumstances, no recording devices while the judge is off the bench, no jurors, no attorney conference, no readable documents, no juvenile proceedings. But this or otherwise prohibited is separate from the subject to the prohibitions of paragraph K. So this is like the or otherwise prohibited is essentially the giant fucking loophole where the court gets to say, no, you don't get to record. It's a public hearing, just like they're all public employees. Yeah. So unfortunately, Maynard, the problem is that there are lots of precedents about recording in a courtroom. You have a right to a fair trial. You have a right to a public trial, and the public have the right to go to the trials. The public have a right to view the trials, and you, as the defendant, have the right to a public trial. But that doesn't mean that you have the right to record in a courtroom. So unless there is a provision made allowing you to record, then the court can prohibit it. So for example, there are prohibitions against recording in California. The entire state, all the courts, you can't record in. Well, state courts, you can't record it. The federal courts, I believe there's some parts of them that allow recordings in their courts. So when you're saying that it's a public hearing, yes, but that doesn't mean you get to record, and they're public employees, sure, but they're also private individuals there. And just because you have a constitutional right to be there doesn't mean that you have a constitutional right to record. So I hope you understand. Maybe you don't, you probably don't, but
I could have showed up at that door, and as soon as you walked in the room and you said, Your Honor, under 122H, I'm audio recording. And that's why in the rule, coverage is defined as cover and coverage. Broadcast is a separate definition under audio. This is the little reason. You give out a Zoom link. What do you mean? This isn't.
Now his ADHD is kicked in and he's gone off the topic. What he's trying to argue is that Rule 122H both allows recording and broadcasting, and that a different section is just the one that talks about broadcasting, covering a proceeding. But his ADHD kicked in, and he is mistaking what the court does, because the court can choose to allow itself to broadcast. Like, why wouldn't they? But his ADHD is all over the place. So he's like, in his broken mind, if the court, who can and does allow itself to record, can do it, then anyone can do it, apparently.
That's not even an eligible argument, because C, if I was requesting coverage under C, you can object. There's no objecting under H, because people can walk in and say, Your Honor, I'm
Mr. Myers,
under H.
Thank you.
You can't, there's no
Mr. Myers,
objection to that.
Mr. Myers, I've heard enough. Thank you. The objection is overruled.
So this is the one objection. She made an objection and it was overruled. I don't think either party made a objection that was sustained in the entire proceeding.
Thank
The
you.
next thing I would like to talk about is, I don't know that we'll have any more hearings on this case, but Mr. Myers, you did email my staff ahead of time.
Yep.
And I don't mind that for logistical type reasons and scheduling type reasons, but emailing substantive stuff about notices and filings, make sure that you just send my staff things that you've actually filed rather than just emails with substantive stuff in it. If that makes sense.
The legal genius, Lane Myers, doesn't realize that he has to actually file the documents. He can't just email them to the judge's staff. Unfucking believable.
Yeah, I called and asked if they want me to send it as an attachment or file it through the court somehow. She said to email it to her.
Right, but just make sure you just, when it comes to substantive stuff, that you only email things you've been filed as opposed to an email that includes a bunch of citations and things along those lines. Does that make sense?
Yeah, you're talking about don't send the request to you?
You can only email me substantive things that you've actually filed with the clerk's office.
Don't email me anything you haven't filed, you fucking moron.
That makes sense.
Yeah, we didn't need to do the notice with the clerk. That's why I was confused. The notice, it literally says to file it with you, not the clerk.
But for example, you sent me an email, you sent my staff an email that had case citations.
Yeah, so they had it ready for you today.
What I'm asking you to do is you to file that stuff with a formal
Oh,
file.
I see what you're saying.
And then
I got it with me too.
if it's important that I get it right away, you can email my staff.
I didn't want you to catch you out with case law and Westlaw and then be like, oh, we got to look it up or something.
Catch you out with case law and Westlaw. So another thing that a lot of these like pro se sov sits like to do is they think that like things that are references, things that are research tools are somehow authoritative. Like Westlaw is not authoritative. What's the other one? What's the dictionary? Black's Legal Dictionary is a dictionary, for fuck's sake. And sov sits and pro se litigants like to hold these things out as being authoritative when they're not. They're reference guides. Westlaw is a tool, one of many, that allows you to research cases and statutes, and it provides you with additional means to basically cross-check things. So like if you look up a statute in Westlaw, it will tell you various cases that define what certain terms in the statute mean. If you look up a case, it will tell you whether or not that case, how many times that case has been cited, whether or not the citations have been positive, negative, or neutral, whether or not any part of that case has been overturned by a higher court. And it'll even let you know, like if other, like for example, if it's a court of appeals case, if other appellate courts have rejected it, have said, you know, I understand that that was a decision in this case, but that's not the way we're going this way. By the power of LexisNexis, I demand the judge recuse. Yeah, I guess. I know you're making a joke, but yeah, it seems to be their thought process. Like I found this thing in Westlaw that says this, and therefore, and they don't understand it, and so they hold it out like a totem, like a charm that will drive away the demons.
Here's
The next thing I'd like to talk about with Mr. Myers is the injunction that was issued. Are you contesting the whole thing?
absolutely every single thing of it.
All right, we have about
So we've had a gentleman contempt of cop who's been very concerned about this. This is apparently what he's talking about. At the ex parte, the terms of the injunction were changed, and so if contempt of cop, if Lane Myers is a legal genius, then this would be Lane Myers' opportunity to provide the legal challenge to this alleged change of the injunction, where he would be able to present cases and statutes and whatever else supports his position that you can't change the terms of the injunction. Although I don't understand this, because the injunction would have issued at the ex parte. So I don't even understand what you mean when you say terms of the injunction. So the ex parte, at the ex parte, the injunction issued in the terms that the court decided it would issue in. But if everything you say is true, contempt of cop, this is Lane Myers' opportunity to challenge it, the constitutionality of it, the statutory requirements of it, etc. So this is his opportunity, and you'll notice that he completely shits the bed and does not. So your argument, contempt of cop, that it is or should be wrong, this is where he would have raised it, and he didn't. So your legal genius is a complete fuck up. He is a complete fuck up. If, as you say, it's true that it was wrong, he fucked up, and it's his fault that he fucked up. So there you go. There you go. Your hero is a fuck up.
an hour left today to get through this. Let me just make sure that we're all on the same page in terms of what we're doing here today.
For those people suggesting that I am live, this is not live. This is a pre-recorded video that I'm just streaming. This is a premiere, not a live. So, I just don't want anybody to think that they could actually interact.
The plaintiff has the burden of proof by a preponderance of the evidence, a little more than 50%. The plaintiff has to demonstrate to me that the defendant committed harassment within the year. Harassment is a series of acts over a period of time directed at a specific person that will cause a reasonable person to be seriously alarmed, annoyed, or harassed, and in fact does so to the person and serves no legitimate purpose. The scope of what I'm looking at today is going to be limited to what's in the petition, what's been filed in the petition.
So if I was Lane Myers, what I would do is I would hammer on the no legitimate purpose part, and I would try to craft arguments and present evidence that would show that there was a legitimate purpose for my contacting the alleged victim. Now, and the reason why is because I think on everything else he would lose, but on oh, Joe, I'm sorry, buddy. It's okay to be gay. It's okay to be gay. All right. We support you. Come out of the closet, buddy. So yeah, I would have harped on the legitimate purpose. And I don't think he would have won, but I mean, he could have at least made a good argument that contacting a member or a director of a law school when he's facing legal challenges might have been a legitimate purpose. I mean, it's weak and I have to think about it, but that's kind of the direction I would go. And someone saying he's not paying attention. Yeah, he's incapable. He's incapable of paying attention. Like the dude's flat broke. He's completely out of attention. He can't pay a cent of attention.
Plaintiff goes first, defendant gets to respond, and plaintiff gets a rebuttal. For the plaintiff, what sort of evidence do you anticipate presenting today?
I believe I have about 12 exhibits.
Have they been marked?
They have.
Given to the clerk?
They were.
Have you shown them to Mr. Myers?
Yes, we share that.
She gave me a disc, sir. That's kind of like 1980s.
It's kind of like 1980s. Yeah. Well, so here's the problem for you. She gave it to you. She gave it to you. She met her requirement. There's no requirement that she give it to you in a specific format. Okay. Don't care. Again, the same thing. You're the same thing. Like your legal genius should have. And hold on a second. Sorry. Okay. Again, the opportunity for Myers to look at it would have been, or to have the court review it, et cetera, for constitutionality or whatever you guys think is the issue. I don't know exactly what you think is the issue. You're just like, it was an injunction and modified an injunction, whatever. I haven't heard a legal argument as to why the court can't do it. So until someone makes a legal argument, I won't be able to address it. And again, now would have been the time. This hearing, November 15th hearing, would have been the time. So
I was told I had to bring it on a USB stick. They showed up with a CD-ROM that we haven't used since 2001.
Have you looked at those exhibits?
I can't.
Do we have hard copies?
I can't. I can't. Well, you can. You can buy a DVD or CD player. They're pretty cheap, like $20. Plug it into a USB, and there you go.
They told me don't. I literally went and bought USBs just for today because that's how.
Let me ask the point. Do we have hard copies of those exhibits?
I don't I have hard copies of the paper exhibits, but not of the digital ones.
Hard copies?
I just have the CDs right there. And then
How am I going to look at the exhibits today? You're in here.
I also have them on a USB, if that's helpful.
It's not helpful because I have to go get a separate computer from IT because I'm not allowed to
Right.
put those things in a court computer. So do you have hard copies of the exhibits today?
Not of, I only have those hard copy discs that I was told to submit to the court.
I'm just not going to be able to look at them at the hearing. I don't know how we get them admitted without somebody looking at them. Mr. Myers, I assume you're not going to stipulate to have them admitted.
Look at this fucking idiot. Like, he has his back to, like, look at this. I remember one time I appeared for a company that I was working for a corporation, in my role as a company officer in a small claims court hearing. Now, the corporation that I was there to represent was a legal corporation, and I am and was an attorney. And I was not taking it very seriously. I should say. It was small claims. And I'm feeling in my britches, I'm big in my britches, that A, I'm an attorney, but B, I'm not appearing as an attorney. I'm appearing as a corporate officer. And I remember I had my hand in my pocket, and the judge admonished me and told me that I had to take my hand out of my pocket and act and treat the court with respect. And my big flaw, my fatal maneuver was just putting my hand in my pocket as I stood at the podium representing the corporation. So, this is so disrespectful. It is just, I have looked at all of the disrespect that Lane Myers was able to give to the courts, the various courts, every single court he's been in. He's been incredibly disrespectful. And it's kind of shocking that people think that you could be so disrespectful and it won't have an impact on the court. Like, I'm not saying that the court will completely ignore the law or anything like that. But I am saying that, like, if the court has to decide, has this guy who's been incredibly disrespectful to me been harassing her? Well, considering how disrespectful he's being to me in court with bailiffs present, he's probably incredibly disrespectful to her and probably is harassing her. You see what I mean? Like, this is Like, you should have learned this basic kind of stuff in kindergarten. Well, so I've also heard 16-0, but he loses in this video. Spoiler alert, he loses, so he's not 14-0. I've never seen anything that would really make me believe that he is actually 14-0. So,
I don't know how to get it without somebody looking at it. Mr. Myers, I assume you're not going to stipulate to have them admitted without having looked at them yourselves?
Her evidence?
Or exhibits?
This is what she gave me.
Are you stipulating to the admission?
yeah, you've already said that, Lane. Like, you don't grasp what the court. You got to listen to the question that leaves the court's mouth. He asks a specific question. How about you give him a specific response?
What's in that disc?
Of course, I want to see it too. But does this court even have a way to play it over there?
Not right now.
Dude, like, how hopped up is this guy on his Adderall? Look at those eyes. Look at those eyes.
Your Honor, we did come prepared with a way to play the exhibits, at least on my computer.
But not on mine.
Mr. Myers,
But not on mine. Fucking shut up, dude.
you keep interrupting. So you have your own computer and you can show those?
Correct. I'm sorry.
You just haven't looked at any of its victories. Oh my God, I get it. So if I disrespect someone, the judge can conclude you harass people. In a trial for harassment, the court can take any evidence that the court deems fit. Yeah. You're getting it. You're figuring it out. Like, don't shit on the judge, and the judge is less likely to rule against you. Yeah, it literally works that way. If you're wondering why attorneys are respectful to judges and why they admonish their clients to be respectful to judges, it's because judges have a lot of discretion. The judges can choose who to believe and who to not believe. And you can't read the judge's mind. So be nice, be respectful, and the judge might rule in your favor. Dumbass. Like, I can't believe these fucking idiots are like, oh, this is reality. This is life. This is how things work. People who like you tend to rule in your favor. People who dislike you tend to rule against you. Like, are you retarded? Jesus Christ on the cracker. And look at this. Look at the body language. Look at the body language of Lane Myers. Like Jesus Christ, bro, hold it together. Look at her body language. She's making eye contact with the judge. She's being respectful. Look at Lane Myers. What is the court going to believe? The court's going to believe this guy has issues controlling himself. If you have issues controlling yourself, you're more likely to be harassing people because you lack self-control. If you have really good self-control, guess what happens? The court's going to be like, this guy has excellent self-control. Why would I suspect that he lacks the self-control to be able to keep from harassing people? Jesus. Do you really not believe that Lane knew immediately this judge was biased? Every judge apparently is biased because Lane reacts this way to every judge. Every judge, every time. You're retarded. Your argument is retarded, and you should feel bad. So, yeah.
Sorry. Yes.
All right. Other than the 12 exhibits, what's your other evidence?
I have those exhibits. I have an opening statement if you would like to hear it, but if you'd like to go straight to the exhibits, I'm happy to do that as well.
Any other witnesses?
No.
Feelings? Yeah, this guy says feelings over the law. Huh. Well, I hate to break this to you, Greg. If you have two people who come into court, one of them says he harassed me, and here are the things he did to harass me. The other one says I did not harass her, and I did not do those things. You have to believe one. Who are you going to believe? Are you believe the guy who acts like a fucking idiot, or are you going to believe the person who's respectful and who makes eye contact and who does all the right things? You figure that out. And once you figure that out, then why don't you come back and let us know? Jesus Christ.
You're going to be the only witness for your side?
Correct.
Thank you. Mr. Myers?
Yes, sir.
What evidence did you anticipate?
What?
What evidence do you anticipate?
The voice, you got this in front of you, like the little order sheet?
That's the
injunction itself, the petition. I plan on introducing on the 9/12, the recording of the phone call, the voicemail, and a copy of the email and paper that I gave them already. And then I have all these YouTube videos, but I'm assuming they're going to play my YouTube videos too. But I need to put them under me too because of a case I have to appeal. You know what I mean? So I'm anticipating having to give you separate.
You don't have to put them under you too. at least not in California. In California, when you appeal, all of the evidence goes to the Court of Appeals. The transcripts go to the Court of Appeals. It doesn't matter who submitted the exhibit. It just matters that the exhibit was submitted and accepted into evidence by the judge. So if she is trying to submit an exhibit, let's say a YouTube video, if you don't oppose it and the judge accepts that video into evidence, then it's available for appeal. So there you go. What is he on? I would assume copious amounts of Adderall. That's what I would assume.
Ones of these, right?
Have you,
Each one needs to have a separate stick, right? That's what they told me.
have you given that to the clerk?
They said not to do it because I only had 3.
Marked as an exhibit?
They said 3, 15 or less, you don't do that.
Have you given it to our clerk today?
This guy right here? Oh, no, I thought you meant like Tom.
I love these arguments. I love these arguments. So can I feel harassed if someone says hello to me? Sure, you could feel harassed over anything. You could feel harassed right now over me responding to you. You could feel harassed. Would a judge grant you a injunction against harassment? No, because there's other elements which you ignore. So, and like this is also another thing. One single voicemail, visitor office once. Yeah, but see, you're ignoring all the other things he did that were harassment. So, yeah. So let's focus on some of the evidence, but ignore all the rest of the evidence. The weird thing is the judges don't seem to be ignoring the rest of the evidence. So you can continue to, but you're going to keep wondering why you get the same results. And you're going to continue to get the same results. That's the problem. You're going to continue to get the same results because you're not understanding. You're not understanding the law and you're ignoring things. This absurd reductionist thing where, so it was one single email. If I leave one single email, it's harassment. No, it's harassment if it's a single email plus all the other harassing stuff. One email, one voicemail. One voicemail would not be enough. Because it has to be a series of acts, right? So it has to be more than one thing. So just right there, like it's not one single voicemail. It is a series of acts. It has to be a series of acts. Oh, Jesus. The stupid is rolling in.
Downstairs. My bad. No, I mean, is that what I'm supposed to do?
Let me just ask her, do you have any exhibits from the defense?
No, I haven't.
I don't know what I'm doing. I'm Lane Myers, legal genius. Is this what I do?
No, I didn't send them. I was going to send them your email earlier, but she said don't do that.
No, don't do that. Let's see what the plaintiff presents.
Thank you.
The plaintiff presents the same thing you're anticipating. We only need to admit it once. All right, Ms. Walker, why don't you raise your hand?
The court knows you only need to admit it once. You only need to admit it once. That's exactly what I said. That's what the court says. And that's what Lane Myers doesn't understand. Lane Myers, the legal genius, doesn't understand procedure.
You have to raise your right hand. You swear to tell the truth at the penalty of perjury?
Yes.
I don't need an opening statement. If you want to go right into it.
Sure.
It's not the talk of a fool, Bobby. It's not the talk of a fool. Is the judge biased? Yes, all judges are biased. You only get a verdict. You only get a judgment if you have managed to bias the judge in your favor. What is not allowable is having out-of-court things bias the judge. So, for example, if your judge goes to coffee regularly with the plaintiff, that kind of bias is not permissible. It is out-of-court bias. But if the court becomes biased by your pleadings, by your actions in court, by the evidence that's presented, by the witnesses, by everything else that goes on in court, that's what is supposed to happen. That is proper bias. So this judge is currently in the process of becoming biased. And he's in the process of becoming biased against Lane Meyer. And every other judge that Lane Myers goes in front of is in the process of getting biased. I don't understand. So in this context, no, she is appearing in her personal capacity. So is she a state employee? Yes. If she was making a decision on which contract to accept to build a new building for the law school, as director of whatever the hell she is. If in that capacity, she'd be a state actor acting as a state actor. In this particular case, she is a private individual who's acting in her private capacity. This has nothing to do with her job. So no, but again, I don't think this is relevant because for the purpose of a slap motion, like if he had filed a anti-slap motion in this case, in the injunction case, then he could at least argue that she is bringing it and she is an employee of a state entity and therefore yada yada. But he didn't bring it, and he brought the slap motion in the context of the criminal case. So in the context of the criminal case, the moving party is the prosecutor. So yeah, I don't think so. So JJ claims to have inside information, but he has done nothing to verify it with me. So take what he's saying with a grain of salt. So just so you know, I don't necessarily trust what he's saying because he's refused to verify, even though he knows or should know that him verifying himself to me doesn't mean that I will leak who he is or what he is.
Your Honor, my first exhibits are related to September 12th, 2024.
What's the exhibit number?
Exhibit 1.
She's in charge of, I'm assuming this is wining and dining the public for funds. That's not a public position. She's a state employee. She's a state employee. I don't understand. I don't understand what your point is. I agree she's a state employee, but in her actions here, she's not acting in the role of the state employee. Your assumption, your underlying assumption appears to be that if you're a state employee, you can only act in a role that is a state action. But a state actor, again, or a state employee can act in a private capacity. Once again, let's go back to the whole thing about, a sheriff's deputy takes a shit in your pool because he's drunk at a party where he's off work and he's just there because he's your neighbor. Can you sue him as a state actor? No, because he was there in his private capacity as a private person. He wasn't there as a cop. He was there as your neighbor. So, don't shit in anybody's pool, but I hope you understand the point.
Can I say something real quick? Can we just make sure that we're on the same page? As far as I was concerned, the only exhibit she could bring we could talk about was these 5 things.
All my exhibits relate directly to that.
Okay. I just want to make sure there wasn't introducing anything that wasn't on this paper.
Thank you. Just we're all clear. It seems like
You dislike Lane Myers, so you dismiss the facts you just flat out refuse to hear. He was allowed to contact her is the point. Yeah, you're allowed to contact people. Like, contacting people isn't harassment. But if you contact them knowing that you're harassing them with the intent to harass them, and you do in fact harass them, and if a reasonable person would think it was harassment, and if you have no legitimate purpose for contacting them, then all of a sudden, bam, it's harassment. So was he allowed to contact her? Yes. If he contacted her and said, hey, I'm looking to make a donation to the university law school. Yeah. Would that be harassment? No. But it was all the other things around it. See, again, you're focusing on a thing. And it's not the thing. If he made 100 videos about her, I don't know how many he made, I don't really care, putting her information up there and encouraging people to call her, and he never once contacted her, he never once left her a voicemail, it would probably still be harassment because he's directing people to her to harass her. I don't understand why you don't figure this out. You keep focusing on it was only one voicemail. It could have been no voicemails. It could have been no voicemails, and it wouldn't change my analysis. I don't think it would change the judge's analysis. Like, you're focusing on the wrong thing. You don't understand. And I keep explaining it. I'm just going to have to assume you're retarded and ignore you. Like, some people can't. Yeah, a series of acts. Video 1, video 2, video 3, video 4, video 5. The videos themselves are harassment. The videos themselves are harassment. The voicemail was harassment also. The visit to her workplace was harassment also. But all the videos that he made harassing her were harassment. Dummy.
We've all agreed that the evidence that I'm here today is limited to the scope of what's mentioned in the petition. There is some leeway on that, but that's the general.
Every single exhibit correlates to the things that are mentioned in Section Exhibit 1, Myers policy work number 250-771-2021 at 8:11 a.m. And going to take a look at
Well, so nervous navigator, there are also some people who are just incapable of understanding. It was a shock to me when I first started making my videos, back in 2018. It shocked me when I first started. I'm like this, like, why don't you understand this? Like, why I don't understand why you don't understand. But there are people who just aren't smart enough. Like they don't. The whole thing, like if you didn't eat breakfast this morning, how would you feel right now? People just aren't there is a percentage of the population, about 15% of the population or so, that is just completely incapable of understanding that. Just it bounces off, So unfortunately, it might not be education. It might just be lack of mental capacity, mental intellect. Like the dude just can't sit still.
Hi, my name is Lane Myers, 520-771-2021.
So this is the totally not harassing voicemail.
Dear Director of Special Projects, well, I'd like to ask if you can approve a special project where you help me and your husband's career for being a crooked ass cop, prosecutor, wannabe.
That's a legitimate purpose. Special project to end your husband's career. That's the legitimate purpose that he contacted her for. Oh, this isn't harassment. There we go. Thank you, JTL.
Whatever he is, hiding these cops from prosecution. I figured the U of A, maybe Stacey could help me. Maybe I should talk to you or Stacey or maybe one of these. But my wife also is an alumni of the College of Law and is actually has taught there. So we got two sides that are about to come crashing together here. So you can help me teach your husband how to follow the law, or I'm gonna take his career. So I figured since I'm a member of the community and my wife's an alumni of the law school, that maybe I can get access to the materials at the law school in order to fight for justice, since Stacey's all about justice. So I guess I gotta call Stacey next.
That's the conclusion of Exhibit 1.
Are you moving for the admission of Exhibit 1?
Yes, I am moving to admit this voicemail.
Any objection, Mr. Myers?
Nope.
It's admitted. And the phone number that was called, is that a work number or home number?
That is my personal work, or my work number at the University of Arizona, 520-626-9223.
And what do you do with the U of A?
I work at the College of Law. I'm the Director of Special Projects. I work with the dean.
Mr. Myers, you have your hands up.
Oh, I mean, I don't know how to I wanted her to finish.
The voicemail is not harassment, just as stepping onto private property is not trespassing. You're allowed to contact a public figure. Then if they tell you not to, then it's trespassing. The level of stupid that flows off this is just absolutely unbelievable. First of all, you'd have to figure out what the state law is about trespassing. You'd have to figure out if there's been notice. If you have been given notice that there's no trespassing in most states, I'm talking about your baseline, bar exam question kind of trespassing general. If you've been given notice that you're not allowed to step foot on, that you're not allowed to enter that particular piece of private property, and you do so, then it would in fact be trespassing. But it could even be so trespassing. There's generally speaking a tort of trespassing, and there's also generally speaking a crime of trespassing. So we would have to figure out whether you're talking. But see, you're so dumb, you don't even know these things. For example, if you're doing a survey across someone's property and you have permission to enter their property to conduct the survey, and you pound in your little stakes and you do your survey, and then you leave the property and you leave one of your stakes behind, and then the farmer runs his tractor over it and it damages his tractor, he could then sue you for trespassing, and he might even win. I don't even know if you realize the complexity of the issues you're talking about, but you're making these blanket baseline statements that are absurd. You are absurd, sir. Like, I don't understand why you don't understand how fucking retarded you are. But you're retarded, sir. You're literally retarded. Stepping onto private property may be trespassing. It also may not be trespassing. I just
finishing then, because I want to make a judicial notice of adjudicated fact.
a judicial notice of adjudicated fact is what he's going for. All right. Well, let's hear what his judicial notice of adjudicated fact is. I think what he's trying to say is that there is some issue that's res judicata.
Hold on one second.
Okay.
You can object.
That's what you're
There's
saying.
an objection, and you need to tell me what that legal objection is.
You're gonna let her finish her little presentation on all the exhibits, and then I go, or each exhibit, and then I go back at her.
Well, see, he doesn't even know how to form a question. What he's mixing up is objections are made in between. So it's for every statement that's made, for every question that's asked, for every document that they move to have admitted into evidence, you make your objections at that time. You don't wait to make your objections, but your objection is different than your presentation of facts. So she presents her evidence, she calls her witnesses, she moves to admit her exhibits into evidence, and then after she rests, after she says, I've admitted all my evidence, I'm good, I rest, the plaintiff rests, then the defendant can proceed to call his witnesses and move his evidence into, or move his exhibits into evidence, right? And then she gets the final chance to rebut that. And then you go into, well, I don't know, maybe generally speaking, she would be able to call rebuttal witnesses. He could call rebuttal witnesses too, but generally speaking, because he comes after, he won't. But for example, if he brings on someone who says, I saw Joe Bob do whatever, then they could bring a rebuttal witness on who can say, well, the witness who just testified has been convicted of the felony of perjury or felony perjury or whatever. So, and then when everything's done on the presenting evidence, then you move on to legal arguments, and the prosecution, the plaintiff, the petitioner makes their first closing statement, and then the defense respondent makes their closing statement. And then the plaintiff, the moving party, the plaintiff, the petitioner, prosecutor would then make their rebuttal closing argument, and then it's done. So it just shocks me that our legal genius, Lane Meyer, doesn't understand procedurally what's going to happen here at this trial.
So she gets to put on her case.
All the exhibits.
Her entire
Okay,
case.
okay.
If there's something you object to, you're allowed to make those objections
In the moment.
in the moment. If it's a legitimate objection. Sometimes that's in the eye of the beholder.
I just wanted to make it known that she is an employee of the state of Arizona.
Mr. Myers,
Okay.
let me finish.
All right.
So I just want to make it known. Well, no, that's a factual assertion that is probably not relevant to this, but so you have to wait for your turn to present facts, you ignorant imbecile.
I talk slowly, and so if you hear a pause, let me keep going. Once she's done with her case, then you need to present your evidence.
So my understanding of Lane Myers is he's not married, so he doesn't have a wife. So your question is somewhat nonsensical. My understanding is his girlfriend currently practices with a firm that does disability law.
Thank you. Go ahead, Ms. Walker.
Thank you. Exhibit 2 is a paper exhibit. Zoom automatically emails me a document that has a partial transcript when someone leaves me a voicemail. It also has my phone number and the phone number that I received the voicemail from. And I would like to support this, submit this for.
See, I love this. Like, the voicemails and harassment. Well, if we take a single piece of evidence out of context and we say that if just that one voicemail had happened, it wouldn't be harassment. And I could agree with that. If it was just that one voicemail, if the only thing he did was that one voicemail, you're right, that wouldn't be harassment. Because there's a definition, it has to be act or acts. And there's other acts. I just don't understand why you don't get this. I don't understand why you don't get this.
Free documentation for this call.
Any objection?
No, I called her. It's my phone number.
Exhibit 2 is a new.
No, I called it. That's my phone number. So you just verified that voicemail, which taken in context with the rest of the evidence, would in fact be harassment. By itself, not harassment. In context with the other evidence, harassment. He intentionally called her. That establishes the intent portion of it.
The next exhibit is exhibit 3. I believe this is the same exhibit that Mr. Myers brought. Mr. Myers emailed my husband at 8:19 a.m. stating,
Objection, Your Honor. This is her husband. The plaintiff is the plaintiff. What I sent her husband is not relevant.
It could be. It could be because you could contact her through third parties.
Objections overruled.
Thank you.
stating that he was going to visit me at the law
The objection was overruled. Thank you. You lost that one, bro, and you didn't even notice it.
school in reference to visiting our neighbors when attempting to cite our home address. This email is exhibit 3, and I would like to admit this document.
Can I see it?
I also bought that too.
Congratulations.
Looking at exhibit 3, it's an email dated September 12th, 2024. Mr. Myers, is that the same one you have?
September 12th at 8:18. I see your wife.
Yes, yes. And this is one of the things that judges can do. The judge can look at the person in court in front of them and make inferences based on their behavior. And people are like, that's fucking terrible. How can that happen? Well, this is how humans work. The judge is going to take lots of contexts about people and determine whether or not he thinks they're a liar, whether or not he thinks they're telling the truth. And it is valid and appropriate for him to do that. It's fucking insane how people think that like the judges can't look at what Lane Myers is doing and draw reasonable inferences therefrom.
We're to the U of A Law School. How ironic. Yeah.
Oh, Jesus. I thought this was America. Yeah, once again, it is not the speech that he makes. It's not the things he says that are the issue. It's the acts that he is doing that are the issue. There could be no speech and you could still harass someone. It is a conduct-based restriction, not a speech-based restriction. But I thought this was America.
Ms. Walker, what is your husband doing?
He is a prosecutor for the city of Tucson.
And does he have any connection with Mr. Myers?
Yes, he was prosecuting a case that Mr. Myers was the defendant in, and he was the defendant at the time that Mr. Myers contacted me.
How do you know that?
I learned that after the fact when I received this voicemail. But at the time, he was still the prosecutor in the case.
Thank you. Go ahead.
The next exhibits are related to September 23rd, 2024. I would like to submit.
Objection, Your Honor. That's not on here. There's no date of September 23rd on here.
Hold on 1 second. I don't know if I said exhibit 3 is exhibit.
Oh, I'm sorry.
It's exhibit. And then the next exhibit is with reference to what?
September 23rd, 2024.
That's not amenable.
What's the objection?
Oh, September. I
What's the objection?
apologize. My bad, Chairman. I apologize. I didn't see the second one. I thought it was 10. Go ahead, sir. Sorry, go ahead.
Thank you for withdrawing that objection. Go ahead.
Exhibit 4 is a video that Mr. Myers posted on his YouTube channel discussing my husband and I. May I play Exhibit 4?
How long is it?
It's
What's he taking notes on? Just out of curiosity, what's he taking notes on?
probably about 10 minutes. There are specific parts that reference to the injunction that I was going to show.
See, there's a lot of people in here. There's this, I don't know if he's Hispanic or just really dark brown, gentleman back behind the alleged victim's husband. And then there's these two guys. These two guys, like he looks like he works. I would bet that this guy works for the government. He just has a government look to him. This guy might work for the government. And I don't know about him, but I just wish I knew who all these people were.
The language that I referenced, I was basically going to just go to the parts as opposed to playing character.
Yes, Paul Carroll is an attorney, and he was being sarcastic. We banter back and forth on my Discord, and Paul Carroll's a good guy. So I hope no one took that wrong. I know Paul understands me, and so yeah, we're all good.
That's not fair. Objection. Context.
That's not fair. Objection. Context. What the fuck is objection? Context? What the fuck does that even mean?
And we'll be here. It's about an hour video. Some of these videos are over an hour, 2 hours long.
Can you lay the foundation for the video?
Yes, I can. The video is important because it's when
How do you know what it is?
my face, my name, my contact information is displayed in
You
it.
pulled up the video? and
Yes, I
watched the
did.
video?
Yes, I've seen it myself multiple times.
Oh my God. The retards never know when to stop being retarded. So I do know the facts. The facts that have been laid out in this particular trial. The facts that have been presented by the prosecution. The voicemails and the emails that have been generated by Lane Myers. It's not about him talking about his case. It's about him talking about his case in a manner that is intended to harass. I just don't understand how you're this stupid. Like you're myopically focused on, I can't talk about my case. No, you could totally talk about your case. You can't do it in a manner intended to harass. That actually does harass, yada, yada. Like, I don't understand how you're this dumb. I mean, I'm surprised you're still breathing.
Exhibit 4 is admitted. We're not going to spend the 10 minutes right now looking at it. Your next exhibit?
That is the only exhibit from September 23rd, 2024. My next exhibits are related to October 2nd, 2024.
This is exhibit 5?
Correct. Exhibits 5, 6, and 7 are related to that.
All right. So if you ask someone, if you call someone, if you call someone to hang up before they say anything every 5 minutes, that wouldn't be harassment. Are you suggesting that no one call would be improper and that's it? Well, this wasn't directed at me, but there is telephone harassment. I believe there is specifically telephone. What state was that in that I covered phone harassment? But yeah, calling someone and hanging up, or heavy breathing, even if you're not saying anything, absolutely could be harassment. It could be harassment. Absolutely, it could be. But calling someone just once, probably not.
Exhibit 5 is also a YouTube video that Mr. Myers displayed on his YouTube channel. I'm happy to play the parts that reference the injunction if you would like that.
How long is it?
There are,
Sir, that's going to violate decorum in this court, like confirms that there's going to be some, but I mean, it's all legal, but you're going to, is there kids in here or anything?
What's the objection? I'm just asking her how long the video is.
It's going to violate decorum.
the part I would like to play is when Mr. Myers specifically states that I got his wife fired, which he has used as the foundation for his harassment.
Objection, Your Honor, that's more along the lines of defamation, not harassment.
Objections overruled.
Thank you.
Can you lay the foundation for this one?
Yes, much of the harassment that I received from Mr. Myers, and as you'll see in subsequent visits from his followers, were based on Mr. Myers claiming that I did something to have his wife fired from her job. And this is the first time that's explicitly stated in any.
That's exhibit 5?
Correct.
That's admitted. Next one.
You don't need to claim that.
So I still find this interesting. So the alleged victim, her only tie to all of this is allegedly she is married to the prosecutor of a case that was dismissed in the Tucson City court. And people are outraged that the alleged victim allegedly got Lane Myers' wife fired. But they're trying to get the alleged victim fired. And that's kind of weird, isn't it? Isn't it? Like, good for the goose, good for the gander. What's good for me is good for thee. What's good for thee is good for me. I mean, like, you guys don't see how hypocritical and hypocritical is the right way to describe it.
The next exhibit is a paper exhibit. In the comments of this video, Mr. Myers responded to a question about saying that I was involved in his wife losing her dog. I would like to admit this is exhibit 6. In the comments from the YouTube video, specifically when someone asked him if they, meaning myself, and I'm not sure if he means my husband or a colleague, were personally responsible for his wife losing her dog.
And you have a copy of exhibit 6?
Excuse me.
Did you hand that to hand it to me? I can take a look at it, and how do you know that these are the comments to the video that's exhibit 6?
The comment that I want to admit is made by Mr. Myers under his handle, that all of these exhibits that is his YouTube channel.
Any objection to exhibit 6?
Yes.
What's the objection?
Okay. What other people said have no bearing on this case, and it's First Amendment protected activity on my YouTube channel.
So I think what he's trying to object based on relevance and based on First Amendment protected activity, but I don't know why. I don't know why the First Amendment, that wouldn't be an appropriate objection, because that would be like legal argument. Her presenting what you said or what was said isn't necessarily saying that it was wrong to say it. She's just presenting it and asking the court to admit it into evidence. Whether or not it was protected speech is entirely different, not objection. So I think his only actual objection here is relevance. So let's hear what the court does with it.
Objections overruled. Exhibit 6
Objections overruled.
is admitted.
So again, big loss. Another loss.
Exhibit 7 is also a paper document.
Another loss for our boy Lane Myers. Oh, I mean, I don't think he has one objection sustained.
Mr. Myers, using the same handle, posted a subsequent comment with my name, place of employment, and stated that my phone number, email, or public information on my workplace website. I would like to admit this document.
How do you know if that's what it is?
It's under the same Lane Myers 2980.
That's me.
Thank you. Any objection to exhibit 7?
Just admitting to everything. Yeah, that's me. Just getting rid of any defense whatsoever that it wasn't him. Just, yeah, that's me.
No, sir. No, Your Honor.
Thank you. Exhibit 7 is admitted.
The next set of exhibits are from October 8th, 2024.
This is 6 or 7?
October 8th.
We're on
8,
exhibit
8, 8. Sorry, I apologize.
Your Honor, this exhibit is a video from YouTube. Mr. Myers posted another video in response to a motion that my spouse filed in his Tucson City Court matter. In this video, he again displays my name, picture, contact info, and room number from the U of A website at approximately 54:58, telling people watching the video to, and I apologize, share the fuck out of this. He stated that all the motion was going to.
So cranky elder God, I'm not keeping count of them, but all objections, both made by plaintiff and defendant, have been overruled. So.
Do was lead to his wife getting phone calls and emails at approximately 1 hour and 18 minutes. He also said, I guarantee you, I'm going to go to the U of A Law School and ask to speak to me at approximately 1 hour, 29 minutes, and 48 seconds. And I would like to admit this.
I don't know if you're kidding on this, but I have seen people mention that Lane Myers believes that Trump will get the charges dismissed. Unfortunately for Lane Myers, what he's currently facing are state charges, and Trump has pardon authority for federal charges. So Trump has zero way of impacting Lane Myers' case. If Lane Myers said that the governor of the state of Arizona might come down and pardon Lane for everything, thus effectively dismissing the charges, then sure, I mean, that could in theory happen. I don't know why anybody would want to do that though. So
Video as Exhibit 8.
How long is it?
There are, it's because many of these videos are long. These are the specific parts that are referenced. I do have the timestamps, and I'm happy to go to them if the court thinks that would be helpful.
And how do you know this video is what you're saying?
It is the same video, the same YouTube channel.
You watched it personally?
I've seen, yes, I've seen all of these videos personally.
Any objections?
Yes, Your Honor. This is getting bad now. Okay, so I got to stand up for a second. All right. So these videos are hours long. The way that you're letting her admit these, it makes it seem like I created this video and it's
what's the objection, Mr. Myers?
14 minutes or whatever about her. That's not true. It's 2 hours. It's not fair. It's about my public record, about my case, about my motions in my case that are public.
So, but she doesn't have an issue with the rest of it. She has an issue with the 14 minutes or whatever it is where you're discussing her. So you're saying that, oh, well, you know, in the other 2 hours, I wasn't discussing her is irrelevant. Your objection is irrelevant. You are irrelevant.
Public records.
What's the legal objection to make?
She's not giving the full video. You need to play the full video.
Objections over.
Overruled again.
Exhibit 8 is admitted.
Would you like me to play?
Okay.
See, the point that he would, what Lane Myers would actually have to do is Lane Myers would have to say, well, actually in this specific video, it says, you know, at this spot that this was satire or whatever, blah, blah, blah. He would have to show where in the video it says something that contradicts what she says, that shows that it's not that way. So, but he doesn't. He just says, well, there's a whole bunch of the video that isn't about her. Yeah. And most of your life is not about her. It's the part that is about her that's the problem. It's the part that is about her that's in front of the court. It's the part that is about her that is, in theory, harassment.
Exhibit 9 is a paper exhibit. After this video, I received 4 phone calls from different numbers. These calls are depicted on Exhibit 9. I would like to admit this document, which shows
See, he gives looks. I don't know if it's to her or to her, but he casts looks over at these, and I think this is his girlfriend, isn't it? Maybe I'm wrong. Maybe it's Maybelline.
phone calls that I received from various unknown numbers immediately after Mr. Myers live streamed.
And the phone calls are to what number? Your work number?
They are all to my work number that was shared by Mr. Myers and that he encouraged people to reach out to me at.
And I was looking at something else. I apologize. Say that again.
They're all to my work number, and they happened immediately the same day after Mr. Myers live streamed and encouraged his followers to reach out to me.
Relax, Lane. Relax. Relax. Don't throw your hands up in exasperation. Relax.
Of course, that's mental gymnastics. There's no way to prove that these people called because of me, and you should.
Objection, mental gymnastics. What the fuck? What's your legal objection, Lane? You're the guru. You're the attorney. What's your legal objection? Like legal objection, lack of foundation, legal objection, lack of authentication. Like what is it? Like what is your legal objection?
Shouldn't be giving out people's numbers. She's so worried about all this. Why is this being put on public record? These random people that we have no way of corroborating if they were calling on behalf of me.
See, he's making a legal argument, not an objection.
What's the legal objection?
My legal objection to her?
But what's the legal objection? My legal objection to her? You're her. This guy's a fucking idiot.
To the admission of the exhibit.
We have no way of knowing that these had anything to do with me.
The objection's overruled. Exhibit 9 is admitted.
Overruled.
Mr. Myers, I hear what you're saying there. That's something for me to decide based on the weight of the evidence.
I'm going to get to argue that, right, when it's my turn to go back? Right, okay, cool. That's right.
Really? So he has multiple restraining orders against him? Interesting. Or I don't know. Maybe I don't know why I would trust you, but sure.
I thought I wasn't sure if I had to make those legal arguments right now or just.
Again, you're interrupting me. I don't think you need to. You're interrupting me. Based on the evidence, I have to figure out. I want to draw an inference that you're causing this, or people are acting. We're on exhibit 10.
Yes, exhibit 10 is a voicemail. It's about 30 seconds. I specifically received 2 calls and voicemails from Deborah Moore at 360-633-9136. The first voicemail is exhibit 10. May I play this exhibit?
How do you know what it is?
It is someone
You
that,
listen to it?
yes, I have. I listened to it myself.
Recorded off your own phone?
Correct. It came directly from my workplace.
Any objections to 10?
Of course. Who is Deborah Moore? I've never met her in my life.
The objection's overruled. You can play. Exhibit 10 is admitted and you can play it.
Any objections? Of course. Who is this other gal? I've never heard of her in my life. That's not a fucking objection. It's not an objection. It's not even in the form of an objection. It's not even in the same state as an objection. It's not even in the same plane of existence as an objection.
Thank you. And I will note that you can hear Mr. Myers' video in the background of this voicemail.
This is not on the paper, sir. It's not on here.
What's the objection?
This is not on here.
What's the objection?
These phone calls were not mad. These were not on the petition. Nothing about other people calling her are on this petition as an act leading to a harassment. This is all going off the rails. You're just, show me Deborah Moore on the petition. Show me the name Deborah Moore on the
What's your
petition.
legal objection?
What I'm hearing you say is you're objecting that the evidence is beyond the scope of the
Of course. It's not even on. Who's
The judge is like, okay, I'm gonna give you this one. I'm hearing you say it's beyond the scope. Are you saying it's beyond the scope?
Deborah Moore?
You're interrupting me. A couple things. You seem like you're getting angry. Your tone of voice is changing.
The judge can't take into account. The judge can't take into account that his actions.
It makes it hard for me to pay attention when that's going on. So I'll ask you to lower your voice. Second, in my opinion, this is all within the time frame, the scope. The petition does mention getting phone calls, so I think this falls within the scope of the petition. Go ahead and play. The objection's overruled. Go ahead and play phone call. That's
Objection overruled. Oh, poor Lane wouldn't know a proper objection if it slapped its dick across his face.
11, right?
This is
Claim the judge. The other thing. Oh yeah, my confidential informant Mackenzie O'Brien doesn't feel safe. She doesn't have any fucking rights because she lied. You're fucked, bitch. You're fucked. You fucked
That's
up
not me.
during that fucking said Greg on 30 days. So you're fucked. Matt Walker, not fucking responsible piece of fucking garbage. Where are you going now? You're gonna like this fucking prison. You're gonna like the prison next door. The general populace got all other fucking properties.
So what Paul is suggesting here is actually very correct. Say, for example, you buy a firearm. Sure, great. Let's say you even buy it legally. You go to the dealer, they do all the proper paperwork, you pass the background check, and then the state brings a case, conspiracy, conspiracy to commit armed robbery, and the action that they show as the step in furtherance of the crime was you buying the firearm. Now it's a completely legal thing, but now you're going to get tried. You're going to trial for conspiracy to commit armed robbery. You haven't committed armed robbery, and the step that they're using as being furtherance of the crime is the buying of the firearm. So yeah, something that can be legal in and of itself, when added together with other things, can all of a sudden become illegal. Driving your friend to the bank and then driving him home from the bank, perfectly legal, except if your friend is there to do an armed robbery, in which case it's not illegal. The context matters. Context matters a lot. You know, you go from doing your friend a solid to being a getaway driver, you know?
And that was exhibit 10. That was a voicemail message left on your work phone?
Correct.
Thank you. Exhibit 11?
Exhibit 11 is this is pretty document for that voicemail that I received on my personal work line from Zoom. I would like to admit the transcript and the phone call evidence of that exhibit.
Any objection to 11?
Yes.
What's the legal objection?
It's irrelevant. It's not in the scope.
Objection over.
Holy shit, he actually made legal objections. They were still overruled, but he actually made legal objections.
Overruled. Our last exhibit?
Yes, exhibit 12 is the second voicemail that I received from this same.
I am taking pleasure in him getting his ass kicked in a pro se proceeding because he pretends he has knowledge of the law. I don't want anybody to go to jail, contempt of copt. I don't want Lane Myers to go to jail. I don't want him to be in jail right now. But I can still take great pleasure in him making an ass out of himself in court because it is his own hubris, his own pride that's damning him. There are great potentials. Like, this is the one thing, like, people like, why did you lose interest in Chile de Castro? Because Chile de Castro figured out he wasn't a legal genius, and he hired attorneys. Now his shit's getting done through attorneys. And can attorneys be good and bad? Sure, whatever, great. But Chile isn't consumed with pride, at least in his legal proceedings, to the point where he thinks that he knows more than the attorneys and the judges. He's given that up. He's now represented. So I am assuming that Lane Myers will also figure it out, that he doesn't know his asshole from his elbow. He doesn't know shit from fuck. He's so far out of his element that all he can do is make things worse. If he represents himself, he will get a worse outcome than if he allows his defense attorney to represent him. If he represents himself, I predict that he will get a very bad result. If he allows his attorney to represent him, I think he will get a lighter sentence. I find it very hard to believe that he will get out of this all scot-free. I mean, it would be nice if there was some way that he could stop harassing Shannon Walker and not do jail time. I don't see it. I hope, but I don't see it. Herb, have you actually seen or heard any evidence that Shannon Walker had anything to do with Lane's wife being fired? I haven't even heard an explanation from Lane as to why he thinks she did. So first of all, there's some assumptions in here that are incorrect. She's not his wife. She is at best his girlfriend. So that's step one. Step two is she was a law clerk, a director of special projects for a law school cannot get a law clerk fired, a federal law clerk. She was apparently a federal law clerk for a federal district court judge. And the federal district court judge allegedly gave her the option of either resigning or being terminated. Now, assuming that she was terminated, she was fired, assuming that she was fired, that would not be anything that someone who is not a federal employee could do. Only a federal supervisor, like a judge or a federal, someone up in like HR, whatever, would be able to fire. Like, it is literally impossible for Shannon Walker, the alleged victim, to have fired Lane's wife or to participate in it, unless you extrapolate it out to the point where the alleged victim suggested that she be fired. If that's the case, then sure, maybe that happened. I don't know. I wasn't there. but I'm pressing X to doubt anything because none of it comports with my idea of what it takes to get a federal employee fired. That is generally the case.
Individual would like to admit this voicemail as individual. It's also about the same amount.
And this is what you listen to on your own voicemail?
Okay, listen to it personally on my work voicemail.
Any objection to Exhibit 12?
Yeah, it's from a random person that has no connection to me.
So the issue is that yes, it is too little, too late. But like, bro, why was he disseminating her information? The purpose behind it that everyone except for Lane Meyer supporters seems to understand is that the information, the publicly available public information, was being disseminated to harass the alleged victim with the intention of somehow having it put pressure on the prosecutor or something along those lines. Like, everyone who's not a Lane Meyer supporter says, yes, he was putting out this information to harass, specifically to get people to call, right, whatever. So, yeah, federal employee. It's hard to get a federal employee fired, and there is no way that a civilian is going to get a federal employee fired. It's just not happening. The harassment statute says knowingly. So you're saying that if Lane isn't aware of what's going on in court. So if you're saying Lane isn't aware of what's going on in court, how's that fit in legally? Well, first of all, you probably need an IQ north of 75 to be able to ask a coherent question. So I won't hold this against you, handyman. The harassment statute that you're referring to, though, is the criminal harassment statute, not the civil harassment statute. Right now, we're looking at a trial for a civil harassment statute. So I would suggest to you that you don't know what the fuck you're talking about.
The objection overruled for the same reasons. Go ahead and play it.
Objection overruled. Yeah, that's precisely what they're doing.
Are you the dumb shit that married Matthew Walker? If you are, you're going down in flames. Okay? Honey, just so you're aware. You're fucked. You're literally fucked. People are going to be fixing your ass in a prison cell for your corrupt husband and your criminal behavior. You're fucking criminals. You think you can pervert justice? We, the people, will own your ass. Move and figure. Get ready, bitch. Get ready. This fucking coming. Yeah, this fucking your ass. Get ready, honey. Cannon. It's coming. You fucked up, honey. You married a fucking ignorant boob. You married an ignorant fucking boob, and he's gonna get you in a whole world of shit. You know that? You just don't realize. You're gonna realize it tomorrow. I guarantee you're gonna realize it tomorrow. You're fucked. All the fucking legal fucking maneuvering and wrangling, you ain't gonna fucking do shit. You're gonna dig your fucking hole in your teeth.
William, just have another vodka. It'll be fine. It'll be fine. We are on 1.5 times speed, and we're only 30 minutes into the video after an hour and a half. So, yeah. Maybe.
You stupid son.
Mr. Myers, when that video was playing, it seemed like you were trying to hold back laughter, and then you kind of raised your fist up as if you were supporting the comments that were in that.
But what happened to the guys? They're like, oh, are you saying that the judge can make opinions based on his actions in court? Yeah, here we go.
My street's a little short.
I don't believe you.
Okay. Well,
That's what
And the worst thing to do is lie about it. Now Lane has shown the court that Lane is a liar. And falso in uno, falsus in omnibus. If you lie about one thing, you're probably lying about everything. There's no reason for the court to believe a word that falls out of this man's lips from this point on. You got caught in a blatant lie, and here we go.
the court's putting on the record. That's what it looked like to me.
That what?
You were laughing and enjoying what you were hearing, and that you were supporting those comments.
I couldn't have been laughing at my text from my girlfriend.
You could have, but
Girlfriend, wife, girlfriend, wife, girlfriend, wife. Huh. So I also believe that Lane Meyer is a liar, a verified liar. So yeah, I mean, I think the court read him like a book and figured out real quick that Lane Meyer's a liar. So I think someone calls him lame liar, and probably a pretty fitting name for him.
But I just don't believe you.
Oh, okay, that's
I was
fine.
watching you closely.
Well, the record will state I got a text from my girlfriend telling me to calm down, but okay.
You got a text from your girlfriend telling you to calm down. Huh. Almost like his girlfriend, who is an attorney, is realizing that the way you carry yourself in court is important. And that he is probably prejudicing the judge against himself. So Lane Meyer's own girlfriend is echoing the sentiment that I had, apparently, allegedly, that you should comport yourself appropriately with proper decorum in court. Be respectful. Don't wave around. Don't turn your back on people. Don't pump your fist in the air. Don't be a general shithead. Weird. Do you guys also think that Lane Meyer's girlfriend is a piece of shit for having the same understanding of that particular bit of what happens in court as I do? Huh. Fucking weird. Fucking weird.
Yeah, roll your eyes.
I don't believe you. I'm just making
I don't believe you.
That's all right. You don't have to believe me. You're next.
Yeah, I don't believe you. He's the judge. No one gives a shit what you believe or not believe. Zero shit's given. Like what? And what a childish thing to say. Well, I don't believe you. What a childish thing to say.
Next evidence.
Yes, Your Honor, I apologize. I said there were 12 exhibits. There are actually 13. Feel free to made the transcript of the voicemail that I recently on my and have listened to myself.
All right. Any objection to 13?
Of course.
Legal objection.
Out of the scope.
So he may be better off just to marry her. I don't know that she would be better off. I mean, he's nothing but a liability. Like he's nothing but a liability. I in a way, I feel bad for her. I mean, women do stupid shit. And eventually, like if they did get married, I mean, I've seen this way too often. Being a first-year family law attorney, like she would get married to him and she would get divorced awful quick because unfortunately, he's a piece of shit. He acts like a piece of shit. He has self-control issues. He has uncontrolled rage. And, it would just get bad. It would just get bad quick.
For the same reasons, 13 is admitted.
Oh, I'm sorry, Your Honor. There is one more final.
14?
This really is the last one.
I don't have that.
It relates to October 9th, 2024.
Let's see what it is.
I don't have it.
1 second. Let's see what it is.
This is a live YouTube video on Mr. Meyer's channel. He went live on his YouTube channel and came to the law school to look for me. This video is exhibit 14. Mr. Myers first stands outside of my office door, approximately 5 minutes and 15 seconds of the video, matching my office door to what is on the website. My nameplate is no longer on the door because it was removed from the door on the advice of the University of Arizona's Red Management Team due to Mr. Myers' actions toward me. Mr. Myers asked various colleagues.
No, I mean, chicks are stupid. Like they're like chicks dig shit. Like he's got a lot of confidence, not deserved, but a lot of confidence. I can understand why a chick would dig him. He's exciting, yada yada. I could see. I'm not suggesting that it's a good idea, but I could see. Yeah, I mean, he's probably a lot of fun. Probably a lot of fun. Chicks make a lot of stupid decisions about who they decide to be with. God bless them.
Where I was and stood outside my office at approximately 7 minutes and 30 seconds. He tells my colleagues that he wants to interview me because I got his wife fired from her job at approximately 15 minutes and 20 seconds. And near the conclusion of the video, he states that he would have to try again to come talk to me at 28:11. I would like to admit this video.
And this relates to the allegations on October 9th, 2020.
Wait a minute. So Lane has represented himself to the court as an attorney, or for the purpose of that he is pro se, he's representing himself. Because that would be interesting. That would be interesting to see. And you say that, but you're not his target audience. You're not the kind of gal who would go for him. Like chicks go after bikers. Go to a biker bar, not a gay biker bar, because you'll get a whole different slew of people there. But like bikers, chicks dig bikers, and bikers are generally speaking not solid husband material. Generally speaking, they're fun, they're violent, they're dangerous. Whatever.
before?
Correct.
And you know this is the video because you watched it?
I did watch it.
Any questions?
Yeah,
Legal objection?
constitutionally protected activity.
That objection is overruled. Doesn't prevent it from being made.
So the only time I have seen him reference himself as an attorney was in the motion to reconsider bond terms. That was where he was representing himself at that hearing, and he cited an American Bar Association model rule of professional conduct. And he asked the court, so to be clear, for the purpose of this hearing, we're considering me to be a lawyer, right? And the judge said, yeah, sure, that's fine. So that's the only way I've seen him mention it. If he does hold himself out to be an attorney, well, that's kind of bad.
That is the conclusion.
Any testimony from you that you want to have, your case in chief? And if so, you can head to your table.
I mean, I think I'm finished. Should I leave the exhibits here?
Yes. Why don't you head back to your table? I'm going to have some questions
I like the tight little cyclist pants.
for you.
Your Honor, should I give these sticks to him right now?
Right now.
Okay.
Ms. Walker, how were the YouTube videos brought to your attention?
I've had initially.
Yes, I also get Eric Brandt vibes. The lack of self-control, the possible abuse or misuse of methamphetamines or amphetamines in general, and the belief that he's smarter than he is. Yeah, he also gives me Eric Brandt vibes.
A number of people reach out to me to say, I heard about this. I've had colleagues who have seen them and sent them my way. Also through my spouse and his work, I just became aware of them. And in Mr. Meyer's channel, I'm sorry, I can't remember how I originally learned about it.
And in videos, according to what you've seen, Mr. Myers gives your name, phone number.
Correct. My name, my phone number, all a workplace phone number, email, office number, encourages his followers to come visit me and says anyone can come visit me. And obviously visited me himself.
And does he say why they should come visit you?
No, my impression has been that it was also that I could be intimidated, and by extension, my husband out of no longer prosecuting this case.
And from your perspective, is there?
So Master Sergeant, I know you are also a civilian police officer. In your experience, do his mannerisms kind of remind you of someone who's tweaking a bit? Like, I would like he seems like he's tweaking on meth to me, honestly. Like he seems just ramped up. It could be like ADD medication, Ritalin, something like that. But man, he just seems like he's banging 110% right now.
Is there any reason Mr. Myers should be having any sort of contact with you?
Absolutely not.
And have you ever told him to stop having contact with you?
We've never spoken. I've been afraid of him. But, Your Honor, I will add that Mr. Myers has never in any way indicated why he would reach out to me for any other reason. And he has explicitly stated it was because I'm married to Matthew Walker, who's the prosecutor, or was the prosecutor in his case.
Thank you. Any other evidence?
No, thank you, Your Honor.
But it's also like the bag of trash. Every tweaker that I've ever really come across has had this irrational desire to have like all sorts of like random shit with them all the time. That's why he just like he doesn't do the jaw movements that I see a lot with tweakers. So maybe it's like an amphetamine, not a methamphetamine, but like he seems like he's tweaking pretty hard.
Mr. Myers, it's your turn to present your evidence.
How do you want to do it if it's the same thing she already?
You don't need to, it's been admitted.
So we can both use that. I can call up exhibit
You can refer to it.
when it's my turn to go up and present and stuff.
You can refer to it. I don't know that I'll let you play it because
His next hearing is tomorrow. So yeah. Yep.
If I want to play it, I need to go through the same thing she just did.
no, you can reference it. It's already been admitted. Just tell me what it is and what about the exhibit you want me to focus on.
Well, I want to admit it so that I can play it.
I'm not going to allow it to be played. We don't have the time today to do that. So you can summarize what's in the video, what you think is important about it.
So we're not going to actually watch the video that led to an injunction?
Not right now.
So the court can take the representations of her and maybe. And then if he doesn't rebut it, if he doesn't say, actually doesn't show what she says, then why would the court have to watch it? Why wouldn't the court just take her version of it? Now, I think the court does watch some of it, but I could be wrong. So you've seen his medical charts, his medical records. Is that what you're saying, contempt of cop? You've seen his medical records? Or are you just taking what he says at face value? A known liar who's been caught in lies, you're taking what he says at face value, aren't you? Aren't you? Sucks, huh? That sucks, doesn't it? It sucks that you're just out here spewing rhetoric that has been given to you by a known, verified, found by a court to be a liar. And you're thinking that that's going to sway anyone. That you think that I'm a moron. I know he smokes weed. I don't know that his father was famous for growing weed, and I don't really give a shit about what his father did or didn't do. But you have no idea whether or not he has Tourette syndrome. You have zero idea. Zero. You're just parroting what he's told you because you're a buffoon, sir and or madam.
You can tell me all about it. Tell me what you think is important about it. It's been admitted.
About her. Am I supposed to be rebutting her evidence or presenting new evidence?
It's your case. It's
I
your
thought you wanted
time.
to go through the computer.
Aaron, I got it.
Am I supposed to be rebutting her evidence or presenting new evidence? Well, those are kind of the same thing. You present evidence to rebut her evidence. So you could present, well, actually, it doesn't say this in the video. You could present someone who says, well, actually, I'm the one who left that voicemail, and I left it because of X, Y, or Z, not because I saw it on Lane Meyer's YouTube page or channel or whatever. So, oh, you've seen his medical records? Well, I would love to know why Lane Meyer's medical records are being spread around the internet, because I'm going to press X to doubt you just as hard as I'm pressing X to doubt the other guy, gal, whatever, the other person. You're tweaking on coward because you'll never show the hearing with Matt Walker and Judge Riojas. You're a pussy dude. Oh my God, it's so cute. That is so cute. Look at him attempt peer pressure. That is so cute. You're adorable. You're adorable. Oh, what do you say, guys? I mean, give him a thumbs up for being so adorable with his little attempt at peer pressure. So adorable.
I got it. Thank you, Pierre.
Don't I got to bring this over here?
No.
Oh, okay.
You don't.
She said to play down there, dude.
It's already been admitted. So
Well, I have different videos too.
what exhibits do you have that are different?
A recording of the hearing with her husband where he asked for the same thing and got denied.
Why is that relevant?
Because her husband, before this injunction was issued, her husband tried to get one for the same reason, and a judge.
The First Amendment activist, I don't know that he was an auditor. He liked to hold up signs and demonstrate and things like that. That was Eric Brandt. Eric Brandt got the way too long sentence for what he did. But you know, that's just my take on it. Your mileage may vary.
Denied it.
All right. I'm finding that's not going to be relevant.
No, for her, he tried to get a court order. Listen, maybe I failed to articulate myself properly. Listen, the case you referred to about him prosecuting, he came to court and asked the judge to issue a change of conditions of release that I couldn't contact his wife or make videos about his wife or say anything about his wife. And the judge looked him straight in the face and said, he's a news reporter. It's First Amendment activity. I can't stop him from doing that. He's not breaking the law. So what they do, they went over to Judge Walton and tried the same thing that they just got denied with the day before.
All right, that's
I think what he's trying to do is he's trying to argue res judicata in some form or fashion, or what's the other legal principle besides res judicata? Collateral estoppel. That's what it was. That's right. So I think that's what he's trying to argue, but he doesn't quite know how to argue it. And there you go.
It's not relevant for what I'm doing here today.
And I also don't think it would be relevant, because I believe the requirements for a temporary protective order, criminal temporary protective order, would be different, and it would be based on the criminal statute, not on the civil statute. So there you go.
Today, I'm my own judge. I get to make my own decisions on it.
Another judge denying it is not relevant.
Doesn't bind me right here, right now.
So you're denying my exhibit?
Yes, I don't think that one's going to be relevant. Do you have another one?
So you're denying my exhibit? Yeah, it's not going to be relevant. It's based on the criminal statute. It's not based on the civil statute.
Am I going to get a chance to make legal arguments?
This is your chance to present evidence. After everybody's done with the evidence, then I'll hear a closing argument.
Okay.
He doesn't, like, I don't know if you guys remember me explaining this, but first one side presents their evidence and the other side presents their evidence, then any rebuttal evidence. And then it goes to the prosecutor, plaintiff, whatever, to make their legal closing argument. And then it goes to the defendant, respondent, to make his legal closing argument. And then the plaintiff, prosecutor, whatever, gets a opportunity to do the rebuttal closing argument. And then it's submitted and the court makes its decision.
Okay, so you see, so I want the email for sure.
I'm not sure you say the email.
The one that she put in here. The one that we said where it says, I see your wait for it, right?
That's been admitted. I can't remember what exhibit it was.
So anything that she already put in that I want to use, don't talk about right now?
You can talk about it, but I'm not going to allow videos to be shown.
I get what you're saying. No, I'm saying, right now we're just saying, do I have anything to add to this, essentially?
Any additional evidence?
Right. Other than this. And that's what I'm saying. I wanted to add that hearing.
And
Okay.
I'm finding like that's not going
Okay.
to be relevant.
And you're saying with other parts of the same video, she wants to admit, there's a video on October 2nd. She wants to admit one part. I want to admit a different part.
It's my understanding is
She edited hers down to like a little clip. I want to play the whole video. I want to admit the whole video for context.
Yeah, but see, you don't get to do that. The context is not relevant of the whole video. The context of what you were saying about her might be relevant. Like if you wanted to show before and after the clip she put out, some parts that are relevant to put what you were saying about her into some context that would in theory make them non-harassment, then sure, maybe to show that there was some legitimate reason to talk about them, not just you wanted to be a dick and harass her.
copy.
Yeah, that's what I'm saying. That's on the sticks.
And which sticks? Show me the sticks.
Yeah, these. I got one for exhibit 1.
You'll be letters.
Hey, I'll be letters? Okay.
How many do you have?
I have 2. If you're not going to let me, right? No on the other one, right?
No on the other.
Okay. So I want to do 2. I want to do,
What will
we
exhibit?
want to call it
What will exhibit A be?
A. A is the video where I went to the school.
So normally the way you label exhibits is if you don't have some agreement between the parties on what exhibits are going to be, if there aren't going to be like joint exhibits, because sometimes somebody will want to exhibit or admit an exhibit for this purpose and the other person will want to enter the exhibit for another purpose or whatever. So normally what happens, at least in California, is that the plaintiff or petitioner, whatever that is, will use numbers. They'll number their exhibits 1 through whatever. And then the defendant or respondent, whatever it is, will use letters. So it'll be, and they do it stupid. They do like A through Z, and then they do double A through double Z, and then they do triple A through triple Z, which always just irritated the living daylights out of me. Why don't they do like A through Z, then A through AZ, and then BA through BZ? But no, they don't want to do it that way. So whatever. I mean, it's not like you're going to get 100 exhibits, generally speaking. It's usually not that big of a deal, but whatever.
That she was referring to.
Okay.
That I stood outside her room and all this. That's the one I just gave her. So that's exhibit A. That's the whole video, not the little 2 minutes that she wants to show. That's
Okay.
going to show proper context of the news report.
1 second.
I don't know if you're being serious, but he's not a genius, and he doesn't know what's going on. And he went to the school. I don't know. I don't believe he attended a law school. He's not showing me any evidence that he's attended a law school. So
Let me see if there's any objection to that.
No, I don't have an objection.
So exhibit A is admitted. Do you have another exhibit?
Yes.
That would be B. Is
Yes. This one is the one she was referring to. Let me see what I want to label this. Like I want to, because I know it needs to be contextualized the right way. Oops.
way to be prepared before going into court, sir.
Can I see that one for a second, just because I want to make sure I'm not giving the same thing twice. I apologize. I thought there's really no way to write on them or anything. Okay. Yeah, it's still A. Still A. I'll just have A. The whole video.
Do you have any other exhibits?
No. We got the voicemail. Like I don't need to give you a stick with the same voicemail that she admitted, right?
Correct.
Okay.
And is there anything about exhibit A that you want to highlight for me right now?
Me?
Yes.
Specifically, yes, my interactions with the staff throughout the whole video, from the time I walk up there, that I ask if it's public, am I allowed to be here? Am I allowed to go in this space? Her colleagues tell me, yeah, go ahead. You want me to go get her for you? They didn't say, oh my God, you can't be here. You got to leave. They said, sure, we'll go get her right now. You want to go to her office? We'll walk you through there. I said, well,
What does this have to do with him being there for the purpose of harassing her? What does it have to do with it? I don't, like, he had no reason to be there. No legitimate reason to be there that I'm aware of. Like, if he could articulate a legitimate reason to be there, maybe.
well, I don't want to go to her office. I don't want to like have her open the door and Lane Myers is standing there. I went there intentionally when she was not there. And that's what the video is going to show.
Okay, thank you.
I rejected, her colleague did offer to take me and I said no.
Any other evidence you want?
Congratulations.
Evidence?
Not argument, but
Evidence, that's what I'm saying. No.
Let me ask you.
It's self-explanatory that the petition is going to be in there, right?
Yeah, let me ask you some questions then.
Sure.
One of the things that I'm going to be asked to think about is whether that can have a legitimate purpose
Of course.
for your interactions.
A legitimate purpose? What? What? Why would the court be asking, like, if there's a legitimate purpose? No, I would never suggest misleading the court, nor would I ever suggest committing perjury. But you can certainly make an argument. Well, I don't know that he can make a good argument, but he could make an argument that he had a legitimate purpose to be there. Legitimate purpose is one of these kind of nebulous things that means whatever the judge wants it to mean. So the judge is going to look at whatever purpose you have and say whether or not the judge finds it to be legitimate or illegitimate. So you can make an argument for it without misleading the court. You can make an argument about why you think it's a legitimate purpose. That's what would argue. He should be wearing a belt.
What is your evidence that what you're doing when you interact with plaintiff is for legitimate purpose?
So you're asking me to make a legal argument?
I'm asking if there's any facts that you want to tell me about that would
Material facts?
prove that you have legitimate.
Yes, absolutely. Absolutely.
So now Blaine is pretending that he understands what the court said and what the court's looking for. And so now he is going to present evidence by way of testimony, presumably, that would show why he had a legitimate purpose for being at the law school.
Absolutely. You want me to start now?
Facts, not the argument.
Oh, not
facts.
The facts? Yes. The facts are that the facts of why I initially contacted
Pull your hands out of your pockets.
her were pretty self-explanatory in the voicemail. The reason I felt like
Pretty self-explanatory in the voicemail. So I don't think that the court heard a legitimate purpose behind you contacting her. I've heard lots of people, lots of Lane Myers sycophants make arguments about why they think it was legitimate, but I've never heard anything that sounded like a legitimate purpose behind that voicemail to me, other than he did it to harass her. So saying it's self-evident or self-explanatory is a bad call. If the court is giving you the opportunity to present facts to show it's legitimate, number one, don't make an argument, and saying it's self-evident why is making an argument. But number two, Jesus fucking Christ, beware mouse is here. Speaking of known liars. Everyone is suggesting that we have, oh, Jesus fucking Christ. What are we going to do? We are going to do a straw poll. Create a poll. Should MERB debate Beware Mouse? Option 1, no. Yes. Watching the only person to score, what was it, 10 times the high score for LSAT would be fun. And we're going to one vote, private address, create poll, and we're going to share. We're going to copy And then we're going to paste as plain text. There is a straw poll now in the chat. There's a straw poll there in the chat. If you want me to debate, probably true. We're not. I don't know what LASAT is. He was there to access the law library. Well, so like if he said I'm there to access the law library, let's say it's open to the public, that might be something that he'd want to say. But why is he live streaming it? You know, why is he live streaming it?
I could contact her because she's a state employee. She's a public employee. She receives public funds. It's First Amendment protected activity. I looked at you can't make legal arguments. I looked at the injunction for harassment rules. She didn't meet the standard. She never told me to stop contacting her ever in my life. I've left one voicemail ever, and she's never told me to never contact her again. All of a sudden, there's this injunction. So, like, if one of the standards is there needs to be more than one, and you need to be told that you're harassing me. I was never put on.
So I don't know where he's getting this. You need to be told you're harassing me. Let's look at ARS 12-1809. All right. A person may file a verified petition with a magistrate, justice, peace, or superior court judge for an injunction prohibiting harassment. If the person is a minor, see, a petition makes it sound like it'd be petitioner and respondent, but the name tags or the place tags show that it's plaintiff and respondent, or plaintiff and defendant. So if the person is a minor, the parent, legal guardian, or person who has legal custody of the minor shall file the petition unless the court determines otherwise. The petition shall state the parent, guardian, custodian as the plaintiff, and a petition with a plaintiff? Fucking weird. And the minor is a specifically designated person for the purpose of subsection F of the section. If such a person is either temporary, unless party requests a petition, files a verified petition for the injunction. I guess more than one defendant. It shall state the following: the name of the plaintiff, the name and address if known of the defendant, specific statement showing the events and dates of acts constituting the alleged harassment, the name of the court, the relief requested, a fee shall not be charged. The court shall review the petition. If the court issues an injunction, yada, yada, shall include the following statement. This is a court order. Yeah. Harassment means yada yada yada. All right. So I don't see anywhere in there, despite what Mr. Myers says, I don't see anywhere in there where the plaintiff is required to give him notice or to tell him to stop. So no poll yet? I'll give you the poll. I know that the poll's open. Poll is open. I will share it again, copy, and paste it. Paste. There you go. All right. So we have votes. Let's see. Live results. It's 50-50 right now. 50-50. So his understanding of what the elements are obviously incorrect, which is sad. One would expect a legal genius to know what the elements are.
Notice. And first of all,
Why do you think you need to be told?
because if somebody's being harassed, you can't just allow the other person to keep harassing them and not tell them. If you feel you're being harassed,
Well, this is an interesting argument.
she needs to go to, like she said, she went to the law enforcement. We'll get into that. But the facts are that she's a public employee. Her email is .edu. Her phone number is listed on a public website, just like your phone number is on a public website, just like your email is on a public website, just like your name's on.
I don't know that so generally speaking, any phone number for a judge would go to the clerk for the judge, not to the judge himself. But good luck.
On a public website. You're both employees of the state of Arizona. It was a legitimate business. I didn't mention the case in detail, all that. I assume she didn't know nothing about it, but no.
Rex says he is wrongfully. You know what? Let's actually see if that is our good friend Rex Fredrickson. Go to channel. This is not the same one. This is apparently a troll. This is not the same one. So sorry, folks, for everybody getting their hopes up. Debate is closed and ended because that wasn't the actual Rex Fredrickson. Sorry, we were duped. We were duped. Duped.
Now she's saying her husband was talking to her about it. Well, that sounds,
This is more like argument.
I feel you.
Any other evidence?
No, evidence-based stuff. No. If you want me to get into my argument, no. Okay.
Thank you.
Case law and stuff, no.
Ms. Walker, rebuttal evidence, testimony, anything?
Your Honor, I think Exhibit 1 speaks for itself. Mr. Myers left a voicemail saying he wanted to speak to me about my crooked-ass husband, who's a prosecutor. He did not want to ask to speak to me about anything that the law school does. He asked to speak to me about my husband, who's a prosecutor in his case.
Who's also a public
That's good. That's good rebuttal evidence.
employee.
1 second.
But see, what she said goes directly to the legitimacy of the contact, right? She's saying that the only reason why I'm being contacted is I'm being contacted because my husband was a prosecutor who was prosecuting his case. So that goes to the legitimacy of why he was contacting her. What the response from Lane Myers is, well, her husband's also a public employee. Well, who the fuck cares? Literally, who cares?
Give me some more detail about what your day-to-day activities are in your job.
I work specifically for Dean Miller. I write his letters, his remarks. I work with various legal boards. I work with attorneys. Mr. Myers is not an attorney.
Do you have any connection with your husband's office where he works?
Do I personally? We work together occasionally. My husband is alum of the law school, and Tucson is a small legal community, as I'm sure you know.
So what she's saying there, I'm assuming, is that because her husband is the alum of a law school, when they get together and they, typically alumni fund the law school. Typically, alumni will give gifts to the law school, tax deductible, etc. So what is important here is what she's saying is, yeah, I work with him, for various things, but she's not an attorney. Again, not an attorney. So she works with the small Tucson community, the small Tucson legal community, because those are the people that fund or who help fund the law school. I don't understand why this is controversial. If they had been asking about, if the court had been asking about any other attorney out there, she would have given the same answer. Now, I think what the court was looking for was do you assist the prosecutor? Does your office in some way assist the prosecutor? And to that, she would probably say no, and that she's not an attorney, and etc. But look at Lane.
Your capacity as a
Look at Lane Meyer. Look at this dude. Look at this dude. He is not holding it together well.
in your job, do you have any connection with the city attorney's office?
Not really. Not really.
Yes or no?
Mr. Myers, you don't get to say that. I'm asking the questions. To my ear, that sounded kind of rude.
My bad.
Please stop.
No, Your Honor.
All right, I've heard all the evidence. Now I will hear oral arguments. We'll start with Ms. Walker because she bears the burden of proof. In terms of the elements of harassment, just walk me through why you think they've been met. And then when I look at the injunction, there is some language in it that does concern me in terms of its overbreadth. The last sentence says the defendant is prohibited from posting any messages or content regarding the plaintiff via any social media platform. That strikes me as broad and probably too broad for constitutional First Amendment type issues. So I'd like to hear your thoughts on that and whether it could be narrowed in a way that would make it constitutional.
So to your question, Your Honor, harassment is conduct, not speech. I have copies of Arizona Court of Appeals cases.
She's correct. Harassment is conduct, not speech.
State v. Brown from 2004 and State v. Snyder from 2024, further explaining that if the court would like to review those.
So the sad thing is the two cases that she cites are cases that deal with the criminal harassment statute. State versus Brown in 2004 deals with the 13-2921, not 12-1809. It's a different statute that has different elements and different requirements. She was wrong to cite these cases. Now, she's not an attorney, but she's wrong to cite the cases. And she's further wrong because one of the cases, let's see if I can get it up. That's what she said. Case law, select courts, Alaska, done. And it's 13-29, 21. Oop, 21. And oop, I selected Alaska courts for some reason because I am dumb. I meant Arizona. Arizona. There we go. And a sort by date. And it was a state, was it State versus Martinez that she was talking about? No, it doesn't sound right. Maybe it was. Yeah, it was. All right, so let's back this up just a tad bit.
Your question, Your Honor. Harassment and conduct, not speech. I have copies of Arizona Court of Appeals cases, State v. Brown from 2004 and State v. Snyder from 2024.
No, it's Snyder, S-N-Y-D-E-R. S-N-Y-D-E-R. Straight for Schneider. Schneider. All right, so this is State v. Schneider. Here is a problem. Here's a problem. It's not citable. So that's a problem. And in addition, it is dealing with a criminal action, ARS 2921, which is a different harassment rule. So she was wrong to cite this. And I believe that the court relies on this decision in its ultimate findings. And that's wrong. And that's an appealable issue. I think hashtag I don't practice law in Arizona. So, take this with a massive grain of salt. But this was a fuck up. This was a fuck up on her part. And this was a fuck up on the part of the court for relying on this.
Further explaining that if the court would like to review this, I'm not asking the court to restrict Mr. Myers' speech on political matters or general topics, but Mr. Myers has harassed me personally and posted videos about me on his YouTube account. In those videos, he has posted my place of employment, work email, and phone number, and office number, and asked his online followers to harass me as well, which they have done many, many times. Thank you.
And the elements for a series of events and why this is harassing and whether or not you actually felt harassed?
In terms of yes, it does.
What are the series of acts?
I believe that is shown in my injunction.
I'm just asking you to walk me through it.
Of course. Would you like to go by date?
First date, when you make a phone call. The other one, September 23rd, October 2nd, October 8th. Let's just take September 23rd.
Sure.
Okay. So the issue is that if you're offering out-of-court statements by a non-party opponent for the truth of the matter asserted therein, it is hearsay, inadmissible hearsay. So if you offer it, if you're like, look, I am receiving these harassing emails, you're not offering them for the truth of anything said in them. You're offering them to show that I'm being harassed. If you go up and here's the emails, and in the email it says that me and Lane Myers are friends, that is not. And that is an out-of-court statement. First of all, sorry, but that is an out-of-court statement. And you're offering it for the truth of the matter asserted therein. It is hearsay. So it would not be simple. It would not be done and dusted on that. I mean, assuming that Myers is competent enough to object on that basis, and assuming that the court won't discount the statement as being hearsay, even though no one objected to it. So basically what I'm saying is you're dumb, you're wrong, you're not an attorney, you have no idea what the fuck you're talking about, and you're criticizing someone who's dumb, wrong, and doesn't know what the fuck they're talking about, while at the same time showing your own ignorance. You should probably stop. Leave being an attorney to the actual attorneys. How about that? How about that?
The YouTube channel, that was not sent to you, right? Somebody told you about it?
Someone told me about it, and then I went and viewed it myself.
So in my mind, it's hard to see how that's directed at you.
I think Mr. Myers
No, because sufficient other evidence was offered that led the court to believe that but for his posts showing her phone number and address, phone number and email address, that she would not have received those offensive comments. You're dumb. You don't know how dumb you are. Again, you should stop because you're just exposing how dumb you are.
Myers says in the video that he studied his opponents and specifically shows my photo after that. And this was also right after he showed my husband's contact information as a prosecutor and implied that I am his opponent.
It's definitely about you, but I don't know how it's necessarily directed at you. But the second saying these videos were not sent to you, someone told you about them.
Correct.
October 8th, there are people calling.
See, directed at you doesn't have to be, he's directed at you means that it has to be communicated. Well, we're looking at, we need to look at the right statute. That's really where we have to start. And it's 12-1809. All right. And harassment means a series of acts over any period of time directed at a specific person. Notice that it doesn't, hold on a second. There was a case that defined the specific person. There was a case that defined the specific person. It was, let's do this. Go back to Scholar. So anyway, for the purposes of, let me just tell you that for the purposes of this discussion, there is a case. I forget which one it is, but there's a case that sets forth that it has to be actually directed at the victim. The specific person has to be directed at the victim. In that case, I don't remember the name of it, but the alleged victim overheard the alleged harasser talking shit about the alleged victim to other people. And the court found two things. Number one, that it was a single instance, but number two, it has to be directed at the person. And the person has to be the victim for the purposes of this. But we do have actions that are directed at the person, and where you go into where an argument could be made is that you directing a third party to contact the victim and harass the victim still makes you the proximate and legal cause of the harassment. I hope that makes sense. Oh, Chris, you're hurting my brain, brother. You're hurting my brain. Why would it matter if this was private information or not? Why would it matter if this was private information or not? Where in this statute does it require private information? Cite to anywhere in there. Anywhere. Do you need the link? There you go, Chris. There's a link. There's a link. All right. Stop fucking talking, you ignorant buffoon. There's the link. Go there. Find any language in there that mentions anything to do about private information. Go ahead. Oh, wait. Go ahead. Oh, wait. That right there is good legal advice. Don't take legal advice from a man who doesn't know how to work an elevator.
Mr. Myers was encouraging his 8,000 plus followers to contact you.
Correct.
What makes you think that he was encouraging them? What in the video supports that?
He explicitly asked his followers to share my contact information and to reach out to me. And the justification was that I had his wife fired.
And then coming to your place of business on the 9th, is there any reason that you would need to do that?
No, there's
Why do you think I'm angry? I don't even understand. Like, are you blocked? Are you blocked? Why do you think I'm angry? Yes, it is possible to have an expectation of privacy in public. And I could prove it. I could prove it. It is a crime to put most places, it is a crime to put a camera on the top of your shoe so that you look up women's skirts. Why? Because they have an expectation of privacy in public. They have an expectation that people won't be looking at their skirts in public. Ergo, you're dumb. Dumb argument.
It's not, there's no reason. The College of Law is a building that has a public law library. Mr. Myers did not have any business to come see me specifically. He claims he's a news reporter. That was news to me. He told my colleagues I had his wife fired. My colleagues were put in a terrible position of not knowing what to say to someone that they knew had been, as far as I'm concerned, harassing me and threatening me with no one around at 5 o'clock on a Wednesday. So it caused a lot of fear and upset for me personally.
And the language that's in there, are you saying that it's because of those cases and the idea that a court can regulate conduct, and sometimes conduct and speech can be mixed together? Are you saying that that language is appropriate, or are you suggesting it can be narrowed at all?
I believe that is appropriate because it refers to me specifically in the harassment, threats, and stalking that I've received, not just from Mr.
You know what's weird? Alpha Fox Adam is an attorney. You know what's weird? It's like all the attorneys can figure this stuff out and all the laymen don't. And all the laymen just make really stupid fucking blanket arguments. Really stupid blanket arguments. Really stupid.
Mr. Myers, but very large extent to from his followers. If I were to put every single thing that had occurred, we'd have about 100 exhibits in terms of names, things that have been said about me.
Why can't an individual post, and I'll just use myself as an example, I mean, someone could post whatever they want about me, nice things, bad things, and you know, it's not directed at me, it's just out there in the public. They're allowed to do that. I know I'm kind of more of a public figure than an individual, but I think it would apply to an individual.
What? Wait, what? I don't know if you heard that, but the judge seems to believe that she's a private individual and that he's a public figure. Well, why? Well, because judges, generally speaking, are elected. Judges, generally speaking, have a lot of discretion to do things that affect the public. For the same reason police officers, even though they're not elected, they're considered to be public officials for the purposes of a lot of First Amendment law. But they have discretion to make decisions that directly affect the people. And so people should be allowed to criticize them. In her capacity, probably not a public official for most things. So I've got to take the dog out. I will let you guys argue. Oh, absolutely. I don't see, the thing is that, like, I don't give advice on how to build a house. And you probably know way more about building houses than I will ever know. And I might even be able to qualify you as an expert witness for the purpose of how to build a house. But as far as the law is concerned, you're a fucking idiot. And you need to be aware that you're a fucking idiot and don't opine on things that show that you're a fucking idiot. Well, you did give legal advice. That's what started this. I was ignoring all of your posts until you said that it would be just so simple. I'm going to have to take this dog out here in a minute. It would be so simple to end this whole thing by offering hearsay. It was dumb. It was wrong. And if you didn't mean it as legal advice, well then, okay. Mea culpa. Maybe I misunderstood you. Maybe you should get better at communicating in English. I'm going to let this play while I take the dog out. So hopefully we'll get it done.
As well, people might send it to me and I might not like it, but that doesn't necessarily mean it's directed at me.
I do believe that it's directed at me specifically because of the contact that I've received specifically at my work email, my work phone number. I'm not really sure what someone might do.
I think that's different. If what I'm hearing you saying is that you're asking me to draw an inference that, maybe not an inference, you're saying there's specific evidence that Mr. Myers is asking others to contact you essentially on his behalf.
I do believe that there is, Your Honor.
And the harassment statute, which is ARS 132921, says that a person commits harassment if the person knowingly, repeatedly commits an act or acts that harass another person. A person knowingly commits any one of the following acts in a manner that harasses. And the first one is contacts or causes a communication with another.
Yes.
And it strikes me that you're telling me that these YouTube videos, what's in them, the fact that your contact information is in them, the fact that they are either explicitly or implicitly encouraging people to contact you, that is Mr. Myers is causing communication through electronic means.
Correct. That is correct, Your Honor.
Just want to make sure I was hearing you correctly.
Thank you.
Anything else?
I do have, I don't know if we're at this point, a statement, if you would like me a closing statement.
I'll hear from Mr. Myers and then you get the last word.
Thank you.
Mr. Myers, your thoughts on all this?
Can I go about what some of the stuff she said?
It's your time to
Okay,
make an argument.
perfect. So as you said, sir, you brought up the original harassment, however, but because this was a voicemail that falls under 132916 electronic harassment. And also in the injunction for harassment statute 121809 subsection E, it literally says the court shall review the petition on file and any evidence offered by the plaintiff, including evidence of harassment by.
Could you just slow down a little bit? I'm trying to listen.
All right, I'm back. Did I miss anything? Yeah. Okay. All right.
Listen to you, but you're going off
My
the
bad. I get worried that you're gonna cut me off. I'm sorry.
Thank you.
Anything else?
I do have, I don't know if we're at this point, a statement, if you would like me a closing statement.
I'll hear from Mr. Myers and then you get the last word.
Thank you.
Mr. Myers, your thoughts on all this?
Can I go about what some of the stuff she said?
It's your time to
Okay,
make an argument.
perfect. So as you said, sir, you brought up the.
He says, can I rebut some of the stuff she says? And the judge says, it's your time to make an argument. Did Lane Myers understand that? Not really sure. Not really sure he did.
Original harassment, however, but because this was a voicemail that falls under 132916 electronic harassment. And also in the.
So 132916, 13 ARS 13-2916. Well, first of all, ARS 13 sounds like a criminal statute because it's in ARS 13. 13 is criminal statutes. And number two, you can see that it is a misdemeanor. So we are in fact talking about criminal harassment. He's not being charged at this time for the purpose of the hearing that he's in right now. He's not being charged with a crime. She's filed a petition for injunction, a petition for injunctive relief. Okay. So don't know where he's going or why he's going there, but that seems pretty stupid.
In the injunction for harassment statute 121809 subsection E, it literally says the court shall review the petition on file and any evidence offered by the plaintiff.
So now he's mentioning 121809 subdivision E, right? And that's right. He's in the right section. But if you look, there is a definition of harassment, and that's what this court should be going by.
Plaintiff, including evidence of harassment by.
Could you just slow down a little bit? I'm trying to listen to you, but you're going off
My
the
bad.
fast.
I get worried that you're gonna cut me off. I'm sorry. The court should.
132921 132921 is a criminal statute. ARS 13-2921. So this particular section, to answer your question, 132921B is people filing false liens. There was a Sav Sit tactic especially to try to disqualify judges. They would file a lien because they believe that what is that universal UCC, Uniform Commercial Code. They thought that the Uniform Commercial Code like superseded all laws or whatever. So they would disqualify judges or attempt to disqualify a judge by filing a lien against them in order to say, well, actually, no, this judge is biased, right? So that's what this particular section was put in to combat. You can't file a lien against a judge or other public official to try to force them to do what you want them to do. If it's a legitimate lien, like let's say, for example, you had a contract with a judge to remodel his house, and then he doesn't pay you, and you file your mechanic's lien on the house, well, then you'd be all good. You'd be all good. Does this section not specifically define a public employee? Does this section not specifically define an employee? Public employee. A person. I don't see where it provides a definition in here, but it's pretty clear, a public officer or employee. So I think it would just use a normal definition of public officer and public employee. A judge would be a public officer. Someone who works like the alleged victim would be a public employee, most likely. Hey, Merb, question. If you have a call recording of somebody making death threats to you, one of your buddies cannot hold any weight in court. Try rephrasing that in English. Try rephrasing that in English. So, all right, anyway, back to this.
This is, I'm reading a section of the injunction for harassment in and of itself statute, 12-1809. It lists them, and then it's what is considered an act for harassment for the purpose of this section. For the purposes of an injunction for harassment, the law is written a little different. The harassment you stated is not the legal definition for an injunction for harassment.
I want to point out that Lane Myers is absolutely correct in what he said here, that 12-1809 is the specific definition of harassment that the court is supposed to be using in this instance to determine whether or not Lane Myers is harassing the plaintiff, petitioner, whatever. So Lane Myers, I mean, for as dumb as he is, he's got this one right so far.
12-1809 E says if any evidence of electronic harassment needs to be reviewed, and then that falls under the electronic statute 1329.
Okay, hold on a second. So it says the court shall review all the evidence offered by the plaintiff, including any evidence harassment by electronic means or communications, determine whether or not the injunction requested should issue without further hearing. Those don't apply if the court finds reasonable evidence of harassment of the plaintiff by defendant during the year preceding the filing of the petition, where good cause exists to believe that great irreparable harm would result to the plaintiff. Injunction is not granted before the defendant or defendant's attorney can be heard in opposition. The court finds specific facts attesting to the plaintiff's efforts to give notice to the defendant or reasons supporting the plaintiff's claim that notice should not be given. The court shall issue an injunction as provided in subsection F of this section. If the court denies the requested relief, it may schedule a further hearing within 10 days with reasonable notice to the defendant for purposes of determining a 1 year period. Anytime that the defendant has been incarcerated or out of state shall not be counted. Okay. So what this is doing is this saying that on filing of the petition and any other pleadings or evidence offered by the plaintiff for the initial restraining order, like for the initial thing, the court needs to determine whether or not the court can issue a restraining order without notice to the defendant, the ex parte, or if the court has to withhold issuing a restraining order until the defendant can be heard, i.e. before there's a trial. So I don't know why he's reading this to make it appear that there would have to be a charge, I guess. I don't really know what he's trying to say. But again, this 13-2916 solely applies to criminal matters. So I don't know really what his argument is. It doesn't make a lot of sense to me, but we'll move on from there. 16, use of an electronic communication to terrify, intimidate, threaten, or harass, unlawful use of electronic device, and that covers social media. That law is newer than because social media is a newer thing than the harassment law. The Arizona State Legislature. it's a newer law. I don't know why he thinks that a newer law would supersede an older law, especially if they're dealing with different things. You could be charged with, for example, you could be charged with this particular statute, the electronic harassment, or you could be charged with harassment generally, and you may even be able to be charged with both, because this encompasses use of electronic means. So you could be charged, like, for example, you'd be charged with armed robbery and attempted murder and murder at the same time. If you killed someone in the course of an armed robbery, you could be charged with felony murder. I mean, you could be charged with lots of different things. You can probably only be convicted of one of them, but I don't understand why. I don't understand his particular. I don't know what he's arguing. I don't know why the newer law would supersede the older law, unless the legislature makes some sort of rule saying all electronic harassment must be prosecuted under this particular one. But then they'd have to amend. They literally have to amend 13-2921 to remove the reference to electronic. So it doesn't make sense.
Recently made 13-2916, and it says it covers use of electronic, because we can all admit the first and initial 912 was a voicemail on an electronic machine, from my electronic machine to her electronic machine, and that's very clear in here that under 13-2916 C, this section does not apply to constitutionally protected speech or activity or to any other activity authorized by law. And when I'm saying,
so what he would have to show, this is where he would show that what his statements are protected by law. But again, he's not being charged under 13-2916. A petition for an injunction has been brought under 12-1809. Now, I think the First Amendment, if your speech was truly protected by the First Amendment, and if it was only speech that was the alleged harassing behavior, then you could probably make a good show of it. But you'd have to actually make the argument. You'd actually have to present the evidence and then make the argument, tying the evidence to it. And he doesn't do that.
saying that this is First Amendment protected activity, because like you said, she made no statements about me giving her the videos or sending them and saying, look at this, or any of that, or okay. I said, here's her contact info if you want to redress your grievances with this public official. I didn't say call.
And again, that is so frustrating. You don't redress your grievances with a public official who's not a public official. I mean, if there was some issue with let's say there was an issue with the way that she decided to spend funds for a special project. And, as an alumni of the law school, you want to complain to her about how she spent the funds. Yeah, that's like reasonable. You could maybe write her a letter or something. It wouldn't be harassment. It'd be legitimately related to her job and everything like that. But again, the First Amendment allows you, it protects the right for you to petition the government for redress of grievance. And what she did is she, as the petitioner, petitioned the government by filing her petition for injunctive relief, seeking redress of grievances, i.e., this guy's harassing me. If he believes the court makes a mistake, he could file a motion for reconsideration or a petition, an appeal. That would be him petitioning the government for redress of grievances.
Call her and tell her about my case with her husband. I said, if you don't feel there's more, I do think she had something to do with my wife getting fired as a law clerk across the street, but that's a different thing. And so.
Oh, Jesus Christ. Holy fuck, you're retarded, dude. You're fucking retarded. Oh, okay. So, how do I say this in idiot? All right. So a third-party communication is just a third-party communication, right? In order for it to be hearsay, you have to look at the reason it's being offered. If you are offering it for the purpose of showing that you were harassed by it, well, nothing in that particular communication has to be true. Shut up, chicken beak. You're also a fucking idiot because you don't know what the fuck you're talking about. Let me deal with one idiot at a time before you jump in and show that you're also a fucking idiot. All right. So nothing in the email or voicemail has to be true for it to be harassing. What you said, Chris, was that you wanted to offer it for the truth of the matter asserted in it. You said you wanted to offer it because it says in the email, because some third party says in the email that he's offering it because of Lane and his friendship with Lane. I hope that makes sense. It's why you're offering it. What's the purpose that you're offering it for? Offering an out-of-court statement for the truth of the matter asserted in that statement is, generally speaking, hearsay. There are exceptions, like if it's a party opponent, etc. So it's why you're offering it. She's offering it because it shows that harassing is going on. She's not offering it for the truth. It is not hearsay for the purpose that she's offering it for. And I just want to point out, just let's get this recorded forever. When you say voicemails and emails are not hearsay, you're dumb and wrong, and you should shut the fuck up. You should shut the fuck up. It doesn't matter if she was in fear or not. You're dumb, you're wrong, you should shut the fuck up. She felt harassed. Doesn't mean fear. You're equivocating between two words that don't mean the same thing. Dummy. Fucking dummy.
That's more defamation, but we're not. So electronic does not apply to constitutionally protected speech. Also, this alleged electronic harassment took place at her workplace, the University of Arizona. That would fall under workplace harassment.
No, it wouldn't.
And workplace harassment, 12-18-10.
Well, okay, so it may, but not in this particular instance, because she's not his employer. She's not an employer. She's not bringing it as an employer or as an agent of an employer.
Against workplace harassment, Section M. This section does not, M2, permit a court to issue an injunction that prohibits speech or other activities that are constitutionally protected or otherwise protected by law, including actions involving labor.
What is it, like 12-18-10? ARS 12-18-10, I think it is. Oh, yeah. All right. So this is ARS 12-18-10. This is the injunction against workplace harassment. Oh. An employer or authorized agent of an employer may file a written petition with a magistrate, justice of the peace, or superior court judge for an injunction prohibiting workplace harassment. She is not an employer or an agent of an employer. It is the wrong thing to bring. Just because there's another statute that you're fucking Westlaw Googling makes you think that she is, holy fuck, motherfucker, dude. Okay. I got to give an explanation of agency law now. Oh my fucking God. Okay. So in order, so you can be an agent for someone else. Like, for example, power of attorney. You're an agent to act on behalf of that person, right? When you're not acting on behalf of that person, you are not acting as an agent. This requires it to be brought in your capacity as agent for the company. She's bringing this on behalf of herself as an individual, not as an agent for the company. You fucking moron.
I wasn't affected by law, including actions involving labor disputes, all that. That doesn't really apply to me, but okay.
Yeah, you might. That's your fucking hint. That's your fucking hint. It doesn't apply to you, bro.
And so, I wasn't residential picketing. That's just I'm just saying what applies to me, the protected speech, constitution protected activity. And then this.
All right. So the difference between a detour and a frolic is on a detour, you're still going about the employer's business. You're still going about the master's business. You're just going out of your way. A frolic means that you're no longer on your master's business, and therefore respondeat superior doesn't apply. Is there anything else I could help you with?
This case has been settled in the area. I know she had hers, but LaFaro versus Cahill made this very, very, very clear. First, there's only one in.
You don't get paid to think, bro. You don't do it well, and you should stop. She is a public employee, but she's acting in her private capacity right now for harassment that is unrelated to her role in that employment. You're dumb. You're wrong. You should shut the fuck up. You should shut the fuck up. Calling her names personally attacked? I don't know what you're talking about. You don't even have to use words to harass someone. You could just call and breathe heavy, call and breathe heavy, call and breathe heavy. You don't even have to breathe heavy. You can just call over and over and over and over and over and over and over again. That's it. That's enough. That's enough harassment. Like I don't understand why people need to read shit in there that isn't there. Like read the fucking statute. Just go by what the statute says. Just go by what the statute says.
One direct contact. That's the voicemail, sir. Voicemail. I called. I left that. We're not here to argue.
No, it's the fact that her husband was a prosecutor. That's why he focused on her. I'm not ignorant. I'm not stupid. I know what the fuck's going on. You're retarded if you think this, it's a role. No, her role as the director of special projects has nothing to do with why he was targeting her. He was targeting her because she was married to the prosecutor and he wanted to put pressure on the prosecutor through his wife. I'm not touching you. I'm not touching you. I'm not touching you. Precisely, sir. Precisely.
That was me. I left it on 9/12. Left that voicemail. That's the one instance of direct contact electronically through the medium of electricity to her voicemail.
Through the medium of electricity.
The rest of them, I made videos on my YouTube channel. That's my first, and I do own Freedom Productions, which is a news and media company in Arizona. So the fact she didn't know I was a news reporter, that's not necessarily my fault.
It's hard to understand more because cops and prosecutors will always reject these cases when a citizen requests legal action against harassment. I hate to break this to you, Chris, but you're showing how fucking retarded you are again, because you might notice that, number one, what we're watching right now is not a case involving a cop or a prosecutor. It is a case involving a private citizen bringing a civil cause of action against another private citizen. So I can understand why a cop or prosecutor would refuse these cases, because these are civil cases, not criminal cases, you fucking buffoon. That might be why. There's your hint. Go build a fucking house, you retard. And if you think that they reject criminal harassment cases, well, maybe you don't understand what criminal harassment is, number one. But number two, I would refer you to the 12 charges or some shit like that, 16 charges that Lane Myers is currently facing for criminal harassment. One could deduce from the fact that Lane Myers is currently facing charges for criminal harassment, the cops and prosecutors do, in fact, from time to time, not reject cases where a citizen requests legal action against harassment. This is a rocket science, bro. How retarded are you? Show me where the cops brought action against harassment committed against you or Tiffany. First of all, I don't fucking know you, and I don't know Tiffany, and I don't really care about you or Tiffany. Second, you live in a different fucking state with different fucking laws. And third, I don't know if you were actually harassed. I don't know if you were. I don't know if what was done to, I don't know what was done to you. I don't know the legal standard that would apply where you live. And so I don't know why, but cops have discretion on whether or not to make arrests, generally speaking, especially for misdemeanors, generally speaking. And prosecutors have discretion when to bring charges and when not. Does that mean that they might refuse to bring charges against somebody? Don't you feud against that jailer guy, JJ, some shit like that? I mean, they might be exercising their discretion, and that might be bad, and they might be biased. But don't extrapolate from your one instance to prosecutors and cops never do this. That's a fallacy. You're dumb. You're wrong, and you're engaging in a fallacy. I'm going to have to stop responding to you, Chris, because you're just so dumb that you make my brain hurt.
She should have done her research. I own a news company in the state of Arizona. I'm a news reporter. It's registered with the Secretary of State. So, I mean, this is what I do for a living. I do news reports. And so also in LaFaro versus Cahill, now I'm going to jump because
Fairhope versus Cahill. That was a good case to cite. That was an excellent case to cite. He is right to cite this particular case. And it does do well for it. Should do well for him if he slows the fuck down instead of talking 100 miles an hour. If he goes through the fact pattern of Farrow versus Cahill. That was the case where the alleged harasser was talking to other people and the alleged victim overhears it, right? So it's a good fact pattern and a good case, and he should address it for the civil harassment, because it's actually a civil harassment case. So he was right to bring it up. He should go into it. Let's see if he could actually make a good argument where he can compare the fact pattern in Farrow versus Cahill and apply the law that was set forth in Farrow versus Cahill. Let's see if he can do it.
It said for under E, back to the original statute, for the burden of proof to get an injunction in the first place. E was we need to look at the electronic evidence in the light of the electronic harassment statute, because the harassment.
And so he provides, like, again, I just want to be clear for all the people who think that I hate Lane Meyer. He had an opportunity before he shits the bed at the end of this. He had an opportunity for and good grounds for appeal. The judge appears to apply the wrong standard. And the issue is that Lane Myers, as a pro se litigant, pro per litigant, is a fucking retard. He doesn't know how to do it. He doesn't know what to present. He doesn't know how to say what he needs to say. He doesn't know how to make a good argument about the cases. Okay? There was a theoretical good argument out there with Farrow versus Cahill. He just shits the bed.
One applies a direct face-to-face or nearby type thing. And then so for the purposes of the section of the injunction, that's under T, 12-1809T. For the purposes of an injunction for harassment means.
Oh, we're back in 1809 anyway. Thank fucking God.
A series of acts over any period of time that is directed at a specific person and that would cause a reasonable person to be seriously alarmed, annoyed, or harassed. And the conduct, in fact, seriously alarms, annoys, or harasses.
You're talking fast.
My bad. It means that it's a series of acts, that would be, I'm just going to read it word for word.
You don't need to do that. I have the statute right here.
Perfect. So
well, then I hope the judge applies the statute. But what his argument is, apparently, that there needs to be a series of acts and he only called once and he only went to the place once. Well, first of all, that's a series of acts. That's two things. But also he's ignoring all the videos that he made that are essentially calls for other people to act in a harassing manner towards the alleged victim. So
I'm focusing on the legitimate purpose part, and you opened with that, so we're on the same page there.
So tell
well, that's good. He's focusing on the legitimate purpose. What's your legitimate purpose?
me what the legitimate purpose was for listening to that voicemail that was Exhibit 1.
So for listening to it,
Yeah. So the judge has come to the same understanding that voicemail, there was no legitimate purpose for it. She's unrelated to the prosecution. She's being contacted because of the prosecution, and the voicemail was unrelated to anything but the prosecution.
or sending it to ask her if there was any programs, because as it states, I mean, I feel like she wasn't completely truthful about her job. It says it right here on the website when you put her name in, that she's the director of special projects at the James E. College of Law. As a member of the dean's office, Shannon manages important strategic matters, projects, and relationships, working with a variety of stakeholders that are both internal and external to the College of Law.
What special project were you calling?
I was calling to see if they, similar to what you asked, I wanted to know if there was any relationship between the U of A Law School and the city's prosecutor's office.
Well, I mean, if he had just called and asked if there was any connection, I mean, if he'd phrased it then, hey, is there any connection between U of A Law and the prosecutor's office for Tucson City Police Department or Tucson City Prosecutor's Department? If he had done that, well, then there wouldn't be a problem. But he had all the extra shit. Like it wasn't legitimate.
where there was any, inside ex parte, whatever you want to call it, type stuff going on there, because Stacey Jane has the access to justice, and I wanted to go use it.
To my ear, when I heard that voicemail, your tone of voice did not seem professional. Your language did not seem professional. You used vulgarity.
I didn't use vulgarity.
Well, maybe that's it.
That was the voice.
Did you want to cry about it? Yeah, I'm a lawyer on my own YouTube channel, and I am very vociferously critiquing people. Yeah. Now keep doing it. I'll fucking do it again.
Voicemail somebody else left.
Maybe that's in the eye of the listener. But
that was a different voicemail.
help me understand why that's.
Because I can. It's my First Amendment activity. I only did it once. And it's my right as a news reporter to call her and address her in my way. I didn't tell her I was going to threaten her, hurt her, any way, shape, or form.
What's the legitimate purpose for going to here?
Threaten, hurt. Again, he focus on the elements. He's not focusing on the elements. He's not focusing on the elements.
Office.
To interview her to see if she got my wife fired. Because so the reason 912 was the voicemail, right? Within 2 hours of 912, my wife was getting an award she was a law clerk for a federal judge across the street.
Wife or girlfriend? Wife or girlfriend? Wife or girlfriend, sir?
Any way, shape, or form.
What's the legitimate purpose for going to her office?
To interview her to see if she got my wife fired. Because so the reason 912.
To interview her to see if she got my wife fired. That doesn't sound like a legitimate purpose.
912 was the voicemail, right? Within 2 hours of 912, my wife was getting an award she was a law clerk for a federal judge across the street. At 2 p.m., she was getting an award on 912. At 3 p.m., she was getting sent home because somebody called over there, and I believe it was Miss Walker.
And I believe it was Miss Walker. That's pretty flimsy. Somebody called over there. And I believe it was Miss Walker. Why do you believe that? Why do you believe that? Well, let's think about this for a minute. Why would he believe that? Let's put ourselves in the shoes of the judge. Why would Lane Meyer, who alleges that he had a completely legitimate reason for calling the alleged victim, right? And his voicemail wasn't threatening or anything like that. It was I just calling to find out if the U of A Law School and the Tucson prosecutor's office, if they had any connection, right? Totally just bland, boring, everyday, journalistic voicemail. But then he thinks that 2 hours later, this gal, for no reason whatsoever, first of all, figures out who his girlfriend / wife is, right? Finds out where the girlfriend / wife works, calls the right person, and has enough authority and sway to get his wife / girlfriend fired. But Lane thinks that this voicemail precipitated getting his wife fired. So why would that happen unless Lane understands that it was a harassing voicemail? Unless Lane understands that it would be upsetting? Lane is basically admitting that Lane, as the objective, reasonable third party, not the subjective recipient of it, would understand the voicemail to be harassing. Does anybody not understand that? Lane is saying that if I was the reasonable person in the reasonable person standard, I would find that voicemail to be harassment. And because I would find it to be harassment, I expect she found it to be harassment, and therefore she retaliated for my harassing voicemail by getting my wife fired. No one? Michelle gets it. Well, thank God someone's paying attention. You all are fighting over fucking Chris in the comment section like idiots. Do you guys realize that this guy is not a legal genius? He shit the bed right there. Like that was his admission that yes, I, Lane Myers, understand that I was harassing her with that voicemail. And people are still just arguing. I'm fucking brilliant. And you guys aren't even taking the time to recognize my brilliance. Michelle does, and that's why I'm going to go down on her later.
The legitimate purpose for including Ms. Walker's contact information in the YouTube videos and asking your followers to reach out to her?
Constitutionally protected activity. I'm going to make that argument right now. So under LaFaro versus Cahill, injunction harassment, which prohibited alleged harasser from any in-person contact with alleged harassment victim, was unconstitutionally overbroad because of its infringement of alleged harasser's constitutional rights to free speech. Alleged harasser was restrained from engaging in political speech in her alleged harassment victim's presence. So what it's saying is I can go there in this very clearly, it says that I can go there, and just because she felt harassed, it literally defines what legitimate purpose is in this case. And so it's defined the fact that you have to have more than, or excuse me, the in-person contact part, that is
Legitimate purpose was defined? Then go over it. Go over it. Explain how what you're doing was a legitimate purpose.
because I have the right to go there and ask her for an interview. And another point I want to make is that she claimed that she contacted her colleagues, or the University Police Department, all that on 9/23 or on 12 after I left that voicemail. She claims that. But then I went there on October 9th to the law library building. Are you familiar with the building? There's a law library in the bottom, and then there's offices upstairs at the U of A Law School.
Maybe it's been a while.
All right. Well, that's the building we're talking about. We're talking about there's the law library and then there's offices upstairs. So she's saying that when I first left that voicemail, she called the U of A police and they told her to take her name tag down, right? And all her colleagues were worried. But then when I went there on October 9th, instead of them seeing me, and they all knew I was trying to harass her, instead of them saying, "Oh, sir, she's not here."
They all knew I was trying to harass her. Did she ever once allege that all of her colleagues knew that he was trying to harass her? She said specifically that she went to the police. She did not say that she went to all of her colleagues. So that's kind of weird. So now you're saying that all of her colleagues knew that you were trying to harass her? That's fucking weird. Like, does he not hear what he's saying?
Here, let's call the police. Oh, we were told to call something. They said, literally, sir, hold my hand. We'll walk you right to her office. These colleagues that were supposed to be so frightened of what's going to happen to Shannon, in the video, you'll watch them say, she's right over here. And I say, no, I don't want to go to her office. They say, oh, it's fine. It's open to the public. You can walk right over there. I'll go with you. So
in the video, I say, no, I don't want to go to her office. And then what do you do? You go to her office.
Well, these colleagues that were put on notice, this crazy man was stalking and harassing her. When this crazy man showed up at her work, they literally, first, I met somebody in the basement, not the basement, the first floor, long before I went there. I said, hey, do you know where Shannon Walker's office is? She could have said, hold on, let me give you.
Are you directing this to me? Did he not have a right to confront an accuser? He has the right to notice and an opportunity to be heard. This isn't a criminal case, so a criminal right to confront witnesses against him would be in the Fifth Amendment. I'm not entirely sure that he has the right to confront them necessarily. The court could, in theory, like for example, the court may not allow him, like in a criminal case, to directly confront anybody. The court may restrict questioning of, say for example, in a child predator case, the least fortunate case out there, the child would be the accuser, and even in a criminal case, you may not get to cross-examine the child. The judge might do the examination. So, I mean, a lot of these things are not necessarily 100% inalienable. They're not 100%. What you call it? They're not bright line. I mean, there's always give and take in rights. They're not really rights. They're more privileges. And it wasn't taken out of context. And what should he have done better? I don't know. If you were fucking listening to me, I already told you, rewind, go back, and there's fucking Jesus Christ, Chris. You got your woman in here trying to, like, why would you fight in the comment sections or on videos that don't even have anything to do with you? Why would you do that? What kind of retard are you? Who are you gonna convince? One of the things that people always want to do, especially in my comment section, right? Especially in my comment section, is they want to debate me. And why would I debate them, right? I won't debate you in my comment section because, specifically, I'm not going to convince you because you're a fucking retard, and no one else is going to see it, so I'm not going to convince them. Will I make a video about it? Because if you're getting it wrong, then other people might be getting it wrong, and therefore I will make a video about it because there are some people who might be open to changing their mind. But I'm not going to debate in my comment section. And I certainly wouldn't go on another person's video to try to make this debate, because no one in here that you're debating, are you ever going to change their minds? You're not going to change anybody's minds. The people who hate you are going to hate you. The people who like you are going to like you, but you're just wasting your fucking time. You're spinning your wheels. Go build a house. Do something productive.
Give you a second, go and call, hey, there's this guy here, he's the guy, he's looking for you, what's going on? Is there something we should be worried about? None of that.
Mr. Myers, I understand the argument you're trying to make there.
Yeah.
On to your next.
Okay, thank you. So the statute authorizing injunction against harassment is not unconstitutional in all its potential, but it cannot be construed to exclude political speech from the definition of harassment. Okay, so in context of injunction against harassment, a single.
So now what you should do, Mr. Myers, is you should cite cases to show that the things you're saying are in fact protected speech.
Incident is insufficient to support a finding of harassment, which requires a minimum of 2 incidents. That's in Wood v. Abril Appeals Court 2018, right? State statutes concerning orders of protection do not authorize their use to discourage people from yelling or engaging in harassment of the type prescribed by statutory provision that governs injunction against harassment, nor do they authorize the use of firearms restrictions to provide incentives for positive behavior or to teach people a lesson about civilized conduct. And you said it. I sounded.
Talking awfully fast again.
I'm sorry.
Yeah, I have no idea what he's trying to go after here.
You referred my language being uncivilized. That's legal. That's what Mayhar v. Cuna, Appeals Court Division 2, 2012 says, that civil, you can't use an injunction harass to teach me how to act civil. Conversation.
Yeah. So what they're trying to get you to do is you get the restraining order to prevent you from harassing, not act civil, prevent you from harassing.
Between alleged harasser and third party did not. Hey, you guys, calm down back there. Did not meet statutory definition of harassment under statute authorizing injunction against harassment. So the third party.
So Chris, here's a little lesson for you. Here's a little lesson for you, Chris. You can't control what other people say, but you can control, in theory, you can control what you say. You don't have to respond to people. Like Beware Mouse has been just shitting the bed in this comment section, and I haven't been addressing anything he's saying. Why? Because I don't have to, and you don't have to. You're almost a full-grown man. You're almost an adult. You should start acting like it. You have what, a wife and kids? Like why are you shitting the bed so bad in comment sections? I see you shit the bed in Josh's comment sections. Stone Vet, whatever he calls himself now. Like, you don't have to respond. Don't respond. Just relax. Ignore them. Ignore them. They'll go away. Once they stop being able to get the rise out of you, they will eventually go away.
Being my YouTube. Hey.
You're not defending kids, you fucking moron. You're not defending kids right now. You're being a jackass in a comment section. You're being a jackass in a comment section. You're not defending kids. I just want to be very real that you're not defending kids. Your kids are here. You shouldn't be either. I'll be perfectly honest with you. You shouldn't be here.
State statutes concerning orders of protection do not authorize, conversation between alleged harasser and third party did not meet statutory definition of harassment under statute authorizing injunction against harassment. Even though alleged harassment victim may have overheard a segment of a conversation, alleged harassing act was not directed at alleged victim. That's the far.
So right there, he's citing that Farrow versus Cahill. What he needs to do is show that all he was doing was having conversations with third parties. Now he's going to have a real problem because again, he went to her work and again, he left a voicemail. And again, the allegation is that he is inciting other people to harass her. So, but he's where he should be, at least. He's where he should be. So if he just slows down and makes a coherent argument, it'll help him.
Really hard for me to pay attention when we're going so fast.
My bad.
My brain turns off.
I feel you. I'm trying to. Conversation between alleged harasser and third party did not meet statutory definition of harassment under statute authorizing injunction against harassment, even though alleged harassment victim may have overheard.
So Mountain Mover apparently says, look at her body language while he's reading it. Yeah, she looks concerned. I'm assuming, this is my assumption, this is just pure, wild ass guessing, that the husband, who is an attorney, helped her do her legal research. And I'm sure that the husband is aware of Farrow versus Cahill and how it could potentially be interpreted by the court as to be detrimental to her case. And so I'm sure there is some concern there because she realizes, I'm assuming that she realizes that it's a dangerous case for her. That's why she didn't cite it. And so, yeah, I assume that she would be tense over it.
segment of conversation, alleged harassing act was not directed at alleged victim. That's again the Farrell versus Cahill, because essentially my YouTube channel is the third party, sir. So when I'm speaking to many third parties. We never refer to it as a 10 party, whether she's one party, I'm the other party, a third party.
Why shouldn't I either find explicitly or by inference that by giving Ms. Walker's contact information, complaining about her and encouraging people to contact her, that's not you causing a communication with her?
Oh, absolutely. We have the right to communicate with her. I want as many.
And that was a shit the bed. He just admitted that the whole point of it was to cause communications, was to cause harassment. He just admitted it. Let's rewind that so people can stop arguing with fucking Chris for a hot second and pay attention to what's going on.
By giving Ms. Walker's contact information, complaining about her and encouraging people to contact her, that's not you causing a communication with her?
Oh, absolutely. We have the right to communicate with her. I want as many people possible to contact her, and they're going to keep contacting her under the First Amendment.
And there you go. Like any argument that anybody wants to make that he's just putting this out there, it's publicly available information, that, you know, he has no intention of causing these communications or harassment, you know, boom, gone, destroyed. Every last person in my comment section who was arguing that it wasn't a third-party communication, you're dumb, you're wrong, you need to fucking move on. Like, holy Christ.
Why didn't you get an injunction against that guy?
Why do you think that it's appropriate?
Because the Supreme Court has ruled on this. I'm going to read it to you.
Why do you think it's appropriate for you, in this case, to encourage others to call Ms. Walker to complain about things?
So people that pay her paycheck have the right to call her anytime they want, as long as they don't threaten her under true threats, which is what I'm going to read right now.
And you
I don't think so. True threats isn't the only exception.
think you're allowed to cause other people to contact her on your behalf?
Absolutely. That's what the news does. They put out a news report and people call and
To cause other people to contact her on your behalf. Let's listen to it again. I'm going to slow it down to 1x speed because he does talk fast. Listen to what he has to say.
To cause other people to contact her on your behalf?
absolutely. That's what the news does. They put
No, Chris, you're dumb and you're wrong. And I'm not going to explain anything more to you than I already have. I'm done dealing with you. So he literally just admitted that he is getting people to contact her on his behalf. Guess what, folks? Anything you say can and will be used against you in court. Everything he's trying to do now in his criminal case, is going to be undermined by the fact that he said that he is doing this to have third parties contact her on his behalf. Not only did he say it, it's the exception to hearsay is an out-of-court statement made by the opposing party. So not only is it not hearsay, but he also said this under oath. He said this under oath, which means that either he sticks with it or he could be impeached over it, i.e., the judge could say, well, were you lying then, or are you lying now? Were you lying then, or are you lying now? Either way, you're lying. Holy fuck, that's bad. Like the people who are defending Lane Myers don't realize how fucking terrible he did, how bad he shit the bed. When I'm like, yeah, he shit the bed, I mean, yeah, he shit the bed. And I suspect he might have lost his right to appeal by the way he handled the end. He might have, I don't know, but he could have lost his ability to appeal. But this is just bad. It's just bad. He shit the bed, dude.
put out a news report and people call. And, you know, I just what you just said, I can go home right now and make a video saying, hey, call Griffin and tell him he doesn't know what he's doing. You can't get me in trouble for it. I've done it with the judge.
Well, a judge is different than her, especially because you're complaining about the judge in his official capacity as an official, as a public official. You're saying this judge doesn't know how to judge, which is a legitimate criticism. Now, the judge has a duty to ignore public pressure, but you're absolutely right to criticize him. But there's a distinction between what the judge is doing in the judge's official capacity as a public official, as a judge, criticizing his behavior there, and criticizing her for being married to a prosecutor. There's a difference. She's not a public official. She's a public employee, but she's probably not a public official. And his concern is not, I mean, he's trying to use it as a smokescreen that his concern with her is based on her status as a public official, but it's more of an excuse than a reason.
Walton when she issued this. So where's the ticket? Where's the charge? You can't stop me. Those same people that called her called Judge Walton as soon as this was issued. I don't see nobody getting charges. I don't see nobody getting injunctions. And what they said to Judge Walton was way worse than what they said in that video.
All right, we got about 2 more minutes, and then I'll hear from Ms. Walker.
Sound judicial policy ordinarily motivates us to avoid addressing constitutional issues unless absolutely necessary to resolve a case. LaFaro failed to establish the statutory requirements for relief under ARS 12-1809, the injunction for arrest.
So that statement that Faro failed, he's referring to Faro versus Cahill. That's a different set of facts than what you have. What you needed to do was establish the facts in Faro versus Cahill, establish the facts in your case, explain why they're related, how they're related, and why it's legally important that the outcome in Faro is going to be the same as you get today. You didn't do it. You shit the bed.
However, we feel, and that deficiency is sufficient to vacate the injunction. Okay. However, we feel compelled to address the unconstitutional application of 12-1809 to permit an injunction placing significant restrictions on Cahill's freedom of speech. The injunction against Cahill was unconstitutionally broad because of its infringement on his First and 14th Amendment right to free speech. I also want to say that the injunction took away my right to the public law library, which is my 14th Amendment. It's a designated public forum, First Amendment protected liberty interest to take away.
I don't believe that a law library is a designated public forum. I mean, he's drawing a lot of legal conclusions that there's no fact to support. I would suggest to you that at best, a law library is a limited public forum. At best, it may be a non-public forum. It's either going to be a non-public forum or a limited public forum. But a law like, for example, my alma mater, their law library is open for alumni and for law students only. It's not open to the public, the general public. It's been established that libraries are public. But holy jeez, like holy fuck, just stupidity, just the fucking stupidity. All right, so let's stop and deal with the retard in the room. So first of all, there are such things as private libraries. There are private libraries. Now, I will grant you that the University of Arizona is a public institution, but that doesn't mean that every area of a public institution is open to the public. And just because it's open to the public doesn't mean it's a public forum. You might notice there's a different word there. Words have meaning, so don't fucking ignore the words. Now, in a public forum, there's different kinds of forums. One is a traditional public forum. Notice it's not just public, it's a traditional public forum. 3 words, not 1. There's also a designated public forum. 3 words, not 1. There's also a limited public forum. 3 words, not 1. There's also a non-public forum. 2 words, one of which has a prefix, but you get the idea. You're a fucking retard, dude. You're a fucking retard.
Way the law library on the pre and post deprivation due process under procedural due process. So there's that whole angle too. They took away my right to go to a public building because she felt some way. That's also unconstitutional.
A public building. Does that mean what? It's owned by the public? It's accessible by the public? A state prison is a public building. It's owned by the public. That doesn't mean you could go in there whenever you want, however you want, do whatever you want. Because it's a non-public forum. And because they can control access to it. They can limit, restrict, or deny access to it. Because it's a prison. But it's still owned by the public.
The injunction against Cahill, 14th Amendment, that's what I was saying, as well as Cahill's right to free speech under the Arizona Constitution. We conclude that 12...
You're reading from the Cahill case. I've read it a number of times.
All right.
So
All right.
So the judge is aware of the Cahill case. So what Lane needs to do is Lane needs to establish that the facts in this case are somehow related to the facts in Cahill, Farrow versus Cahill. Holy Jesus. Oh my God, you're dumb, motion mover, mountain mover, whatever the fuck you are. You're so fucking dumb. Just non sequitur after non sequitur. He needs to establish the facts in this case are akin enough to the facts in the Farrow versus Cahill case, and then make an argument as to why the outcome in Farrow versus Cahill should be applied to this case.
Anything else you want to stress?
I want to get this on the record for my appeal.
You don't have to, you referenced the case, so everyone can pull up that case, it'll be there. It's in the record. Any sort of case that you refer to has been reported. The appellate court can pull it up themselves and read it. So,
Wow. So what, you want some more, you want a different one you're saying than that?
no, I'm giving you about a minute to finish your argument before I get to this.
Okay. Then we got Counterman versus Colorado. The Supreme Court held the First Amendment permits restrictions upon the content of speech in a few limited areas. Among these historic and traditional categories, unprotected expression is true threats. True threats are serious expressions conveying that a speaker means to commit an act of unlawful violence.
The mistake he's making here is thinking that only true threats are unprotected speech.
The existence of a threat depends.
And again, if you looked at the cases I posted last week, like first of all, Farrow versus Cahill, let's pull it up. LaFaro versus Cahill. So they look at it, and because it's limited by, it has to have a legitimate, has to serve no legitimate purpose. That's what they're looking at, and they also are looking at conduct. So there is a lower threshold, a lower constitutional threshold on conduct, and in this case specifically, they don't have to deal with it because if you can show there is a legitimate purpose. If you can show a legitimate purpose, then bada boom, bada bing, it's not harassment. So that's what LaFaro versus Cahill shows. But his argument about true threats, it's misplaced. No one is arguing that he made a true threat. They're arguing that his conduct was harassing and it served no legitimate purpose.
Depends not on the mental state of the author, like you said, but on what the statement conveys to the person on the receiving end. So my mens rea doesn't come into that. Yet the First Amendment may still demand a subjective mental state shielding some true threats from liability. That's because bans on speech.
I don't really fucking care. Like you could try to tone police me all you want, but that's just retarded. Like who the fuck are you to try to tone police me? First of all, get the fuck out of here. You know what? That deserves that you get a little time out. Because fuck you, that's why. Because fuck you, that's why, you retard. You giant fucking douchebag retard. How about that? Does that make you feel better? Does that make you feel better? Dolores Claiborne? Go fuck yourself. Don't police me.
Speech have the potential to chill or deter speech or outside their boundaries. And important to prevent that outcome is the condition liability on the state showing of a culpable mental state. That kind of strategic protection. What?
Again, just reading from a case.
That's what you do. You cite case laws.
No, you make legal arguments. You say, in this case, these are the facts. In this case, these are the facts. In this current case, these are the facts. And so because of that, we think that the law that was applied in this case should be applied in this case. You don't just read citation after citation. This is in a memorandum of law. Then you would put like the actual specific text that you're looking at, the statements of law. But here you're just trying to make an argument.
You don't just read from the case.
You do. I'm citing a paragraph in the case.
We have limited time.
I have as much time as I need to make my arguments.
We have limited time.
That's your.
Why does he challenge a judge so much? I would assume oppositional defiance disorder. I would assume. But yeah, he doesn't do himself any good. The judge can control the courtroom, and Lane Myers has no power to do otherwise.
Well, then continue until tomorrow and we'll keep going.
I will not.
You don't get to just tell me I only get 5 minutes to talk.
I actually do. I get to manage my courtroom how I think is proper.
So
you don't have to agree with it. You got 30 seconds more to tell me what that is. I read that case. I'm aware of that case.
So why are we still standing here?
Well, because I need to hear on both sides and then make up my mind. Anything else you want to say?
Yeah, that I don't care about contacting her at her house, but you can't take away the law library, and you can't take away my YouTube, and you can't take away my First Amendment right. I called her for what I made it clear. I want to know.
Well, despite the statements of what the judge can and can't do, reality would suggest otherwise.
Do you got anything to do with my wife? And if not, okay.
All right.
I don't need to contact her for that,
Thank you.
but I can go to the law school.
Thank you. Ms. Walker, you get the last word. I'm still struggling with that last sentence.
Well, you'll struggle with it all the way to this special action.
And don't threaten a judge with a special action. Like you're not. It's not like if the judge makes an error of law, you file an appeal or a petition for writ of mandate or petition for writ of prohibition. You file a petition or an appeal. You don't file a special action, and you're gonna lose if you do file the special action because the judge is making a decision in a case, etc. Like, yeah, and the judge probably won't even judge probably won't even have to make an appearance. It's probably going to get dismissed before the judge even has to do anything. There's going to be lawyers that the county is going to have defend the judge. I mean, it's preposterous. It's a waste of time. I don't understand why sovsits like Lane Myers and Chili DeCastro, why they think suing judge and James Freeman, why they think suing judges is a fucking good thing to do. Like they have immunity for the decisions that they make in a case. The judge is making decisions in a case. Judicial immunity would apply. Like, I don't understand.
Mr. Myers, if you interrupted me again, it's rude, it's not nice, it's unprofessional.
I know.
Please stop it. Ms. Walker, can you address that concern? Again, I just think the language is broad. I understand why you want it. I'm just not sure it's constitutionally allowed.
I believe because it applies to me specifically, Your Honor, because it has caused me more emotional distress than I can.
Is that what he's doing? He's filing it's a petition. We call it a petition for writ. Okay, so all right, so mea culpa. If all he's going to be doing is filing a petition for a writ of mandamus, then okay, but good luck, good fucking luck, and the judge doesn't care because the judge is going to couch a lot of this in such a way that it doesn't really matter because the judge is going to make findings of fact. And when the judge makes those findings of fact, it's going to be super duper hard for him to be overturned because of the specific findings of fact that the judges make. Now, could it be referred back to, could you get a successful appeal? Yes, but it would be referred back to the judge, in my opinion, for the review to be done on the basis of the law that was used to come to the conclusion. So when I say a successful appeal, I mean, the end result would be to come back to this judge, it'd come back specifically to this judge, and this judge would apply the correct set of facts and law to come to the, quote, right conclusion. The judge does not have to accept a writ of mandamus in the appellate court. I don't know what you're trying to say. He has to create a standing and get it accepted. I don't know what you're trying to say. The way petitions for writ work in California is you file your petition for writ in the Court of Appeal against the judge, and the Court of Appeals will then either issue the writ, they'll deny the writ, or they'll accept it for argument. So I don't know what you're trying to say. I know what each individual word means, but when you smush it together into those two sentences, it doesn't make any sense. So I don't know if you're high or what, or you just don't know what you're talking about. Mandamus is not guaranteed. No shit. That's why you petition for it. So maybe you don't know what the fuck you're talking about. I don't know. See, I don't practice law in Arizona. If a special action is a petition for writ of mandamus or a writ of prohibition, if it is, then okay. If it's something else, if he's suing like for declaratory or injunctive relief or something like that, then it would be different. I literally just said that, idiot. Wow, aren't you a Like you said something really fucking stupid, which wasn't what I just said. So go fuck yourself, retard. All right. Anyway, back to this.
Didn't really mention here. I feel harassed. I feel threatened. I feel frightened. I couldn't put my children in this injunction against harassment because I knew exactly what.
This motherfucker just spun his back. So she does have to prove that she felt harassed, and also I think a reasonable person would find that it was harassing. Yeah. So it would have to cause a reasonable person to be alarmed, annoyed, harassed, whatever, and it also has to alarm, annoy, harass that person. So there's a subjective and an objective standard. So she is testifying to the subjective standard.
What Mr. Myers would do. I don't know what his fathers would do. I don't know if they would try to look them up or call their school. This is fear I've had every single day. And Mr. Myers and his YouTube channel and his followers who are here in the courtroom, I don't know any of these people who are recording me right now because I work at a law school and I'm married to a prosecutor. I find that very hard to understand, that I'm getting phone calls saying I should be raped and thrown in prison.
I don't agree with
Mr.
that.
Myers told them to call me over something that is not true. And even if it was, Mr. Myers' wife, who I have never met, I don't know if she would exist.
Is this Christopher Ruff? Is this the guy from Arizona who's currently a fugitive? I think it is, huh? Yeah. Well, good luck to you, sir. I hope you achieve a outcome that doesn't result in you being imprisoned. How about that?
Has other legal remedies that she can follow other than her husband getting on YouTube.
But you clearly don't know what the fuck you're talking about from a legal perspective. So, I mean, procedurally, it might be a writ of mandamus is a special action in Arizona. They call things different names. And I don't know, I'm a California attorney, not a Arizona attorney, but you said some fucking really dumb shit there, dude. Like, that was word salad, and good luck.
Making false claims about me, questioning my ethics and my morals, my professionalism, and making my life.
I thought you preferred it directly inserted, sir.
What it has been for the past 3 months.
All right, thank you. I'm gonna take a short recess and think about this, and I'll come back and I'll give you my decision. Once I leave, all the recording devices need to be turned off, please.
All rise.
Like, with who? With who, concerned citizen? I lost credibility with who? Because I only care about my credibility in very, very specific instances and with very specific people. So, good.
Thank you. You may be seated, sir. When I say all rise, that means everybody. Okay. Thank you.
So apparently the judge just went back to review some of the videos. So.
Am I allowed to say anything?
Not right now.
All right.
Am I allowed to say anything?
Not on the record.
Thank you. That's kind of what I meant. Can I say something to her, like, politely? All right, cool.
No, you're the restrained party, bro. You're not supposed to be talking to her, not even politely. I mean, it's his opinion that I lost credibility, but that's fine. He's entitled to his opinion. I don't really give a fuck. That's my whole point. Like who the fuck are you? Like, if I don't know who the fuck you are, don't really care, but okay. Is this what he's writing? And how did you get this up on the, or did this is a public service insert this? That's crazy. Huh. Well, he was pumping his fist. He was pumping his fist in support of what his supporters were saying on voicemails. So, I don't know. I don't know. It would be crazy if he did. Actually, if the funny thing is, nice attempt to insult me, and that's fine. But I was actually I took the last 3-day bar exam. This is all verifiable, obviously. And so when I passed, it was like a 33% pass rate. I took the February of 2025, California, February 2025, no, 2017 bar exam results. Oh, poop, I was wrong. Share this tab instead. So 34.5% of applicants passed the February bar exam. Yeah, 34.5. So you're dumb, you're wrong, you're provably dumb and wrong, and oopsie fucking doodles. True. No, 7 years, because I didn't take the MPRE until, was it June or July of 2018, whenever it was. And then that's a multi-state professional responsibility exam. And then after I passed that, I didn't really expect to, but after I passed that, then I had to do the background check, and that took until like February or March. No, it had to be February, because I started practicing law in March. So end of February, beginning of March is when I finally got back the clearance from the bar of 2018. So 7 years. See, who's he talking to? Who is he talking to? The women seem kind of freaked out. The two guys in suit jackets in the back didn't respond. The husband, the Tucson City prosecutor, didn't respond. Huh.
All right, we are back on the record. Thank you, everyone, for your patience. All this paperwork is now online, and I'm not the best typist, so that's why it took me a little while. What I'm going to do now is tell you what I'm going to do generally. I'm going to explain why I'm doing it. When I'm done, I'll see if anybody has any questions or wants to make more of the record. I'll start with the plaintiff, and then I'll go to the defendant. Here's what I'm going to be doing. I'm going to be affirming the injunction. I am going to be modifying it, however, and I'll talk about the modification.
So when people say that that Lane Myers is 14-0 or 16-0 or whatever number they're making up, well, this is a 1. He lost this one. This is a 1.
And why I'm modifying it in a minute. In terms of my findings, I am finding the plaintiff is credible and she is believable, that she definitely feels like she.
So I thought that the one in pink back there might be his girlfriend, wife, whatever, but I am told that that is not. So I don't know. I mean, people are like, I've seen pictures of her and that doesn't look like her. Well, I've seen chicks take pictures where they don't look anything like they do in real life. You know, they got all that makeup slapped on and their hair did and yada, yada. Is he in jail for having a really poor legal argument, or is he in jail for breaking the law, in my opinion? In my opinion, he is currently in jail because his bond was revoked because there was a something evidence or great, what's the Arizona criminal rule 7.2. He is in jail because there is evident proof or great presumption. Whatever that is, I don't know what it is. I don't know. I haven't bothered to look up the level of proof that is. I don't know if it's more than. So what Myers' attorney was saying at the hearing was that it's more than it's more than was it preponderance of the evidence? Did he say it was more than preponderance of evidence, or did he say it was more than probable cause? I think he said it was more than probable cause. So I don't know exactly. But whatever it was, a court found that there was evident proof or great presumption that he said stronger than preponderance. Stronger than preponderance. So preponderance is 51%, or anything greater than 50 to anything less than 50. Not stronger? You said that wrong. I thought he said it was a higher burden of proof than why did I just go blank? Probable cause. I thought he said it was higher than probable cause, and based on that, he wanted the arraignment to be that day. So, so court found that there is this, whatever it is, that he committed a felony. So that's why I think he is in jail currently. Do I think that he actually harassed her based on the evidence that I have seen at this trial, and based on my understanding of the law? I think he was actively in violation of she proved that he was harassing her. I think, yeah. As far as the criminal harassment, because there is an underlying order against harassment, do I think that he criminally harassed her? I would say probably. If I was going to bet on this, I would bet that he gets convicted. I don't want him to get convicted. Again, I don't want anybody to be in jail. That is not my hope. My hope would be that the outcome of this would be that he could somehow stop harassing her and not go to jail. That would be my hope. I don't want anybody to go to jail or prison. And I think that the potential penalties that he's facing, in my humble opinion, obviously Arizona disagrees with me. I think, bro, that seems pretty stiff for what he actually did. But I would strongly suspect that he's going to get found guilty, or he'll take a plea. I think if his one of the reasons why I really hope that his lawyer, that the public defender, is forced to represent him. I really hope that the public defender is forced by the court to represent him, even if it's against Lane Meyer's will, because I don't see a good way out for him. And the public defender might be able to get a plea deal. So, I hope the best, but he certainly, like all of the statements he made in this hearing that we watched today, were pretty damning. They were pretty damning. So, if the And I don't know that Lane Myers realizes how damning it is. I don't know. Oh no, they're much higher now. They're much higher now. I think as a matter of policy, they changed the bar passage rates to 2/3 passage. And I don't know exactly how they enforce that. I think they changed them in 2018 or 2019, or 2019 or 2020. But yeah, they're different now. So I think it's a 2/3 passage rate, and it's somehow enforced. So like if everybody's a complete fucking retard, you'll still get 2/3 passage. So yeah. So anyway, well, we still need to watch him spurg out. So we'll finish up and watch him spurg out.
I find this is all credible there. I don't feel the need to look at videos. I think that's why I'm modifying it in a minute. In terms of my findings, I am finding the plaintiff is credible and she is believable, that she definitely feels like she's being harassed. I found everything that she told me, not only about her feelings and what she's going through, but also just the facts, her summary of the videos. I find this is all credible there. I don't feel the need.
So for those of you who aren't figuring this out, the judge is saying that from the videos, from her description of the videos, she's getting harassed. So if you think that she can't be harassed from the videos, there you go. The judge has said she can. And the judge should know what the law is.
To look at videos. I think both parties have talked about it. As for the defendant, I am not finding him credible. I do not believe much of what he says. In particular,
see, that's also very bad. So the judge, as the finder of fact, it's very hard to overturn a finding of fact at an appeal level. So the judge saying that he's not credible is very detrimental to him on any appeal. I mean, good luck, dude. And again, even if he does win an appeal, it would most likely be an appeal of the law. Like if you appeal based on the law that it appears the court applied, there's a good chance he'll get sent back to this court for the court to issue a new order based on the correct law, but the court's just going to issue the same order. Like, I don't see this solving anything.
When he laughed, in my opinion, it's funny that he laughed and was excited about the voicemail from the third party and the awful things that were said about the plaintiff.
Objection, Your Honor.
You can't object to what I'm saying.
Oh, the timeout passed. So I'm not representing anybody here. So Dolores, here's the thing. This is unprofessional what I'm doing. I don't do this for a living. I'm not a professional streamer. I'm not monetized. I'm not acting as anybody's lawyer. We're not in court. I don't represent anybody here. So this doesn't affect my professional credibility, because how I handle myself with my clients and in court is what affects my professional credibility. So you're fucking retarded. You're dumb and you're wrong. Thanks for playing. And back to timeout. Enjoy. It won't let me do it. Oh, poo. Oh, poo.
I can do whatever I want.
Actually,
Wait,
no,
what?
Objection, Your Honor.
Was excited about the voicemail from the third party and the awful things that were said about the plaintiff.
Objection, Your Honor.
You can't object to
You can't object to the court's ruling.
what I'm saying.
I can do whatever I want.
I can do what I want. You don't know me. I do what I want. Jesus Christ. This guy's a fucking moron.
Actually, no, but it is rude. I'm just explaining myself.
You're being rude.
Look at this guy. Like, oppositional defiance disorder. He can't just accept the fact that he lost.
You gaslight me by telling me what I meant when I told you my girlfriend texted me.
Giving you a chance.
He found what you said to be not credible. And just because you want to pretend that that's actually what was going on doesn't change anything. The court found as a finding of fact, as the finder of fact, that what you said was a lie. And that's it. End of case. End of discussion.
Chance later to talk about. I make me find the fact.
It's not a finding of fact, it's a finding of opinion. It's literally called an opinion.
Well, we'll disagree on that.
It's true. It's true. Technically, he could say, I object. And he did say, I object. However, it has no legal significance. It is a waste of space. It is a waste of time. And it could, in theory, bias the judge further against him. So Sure.
So those are my credibility determinations.
Yes, Simba B. Are you related to USB? The court finds. So there is at trial, the reason why you're presenting evidence is because there's going to be a finder of fact there. And the finder of fact's role is to determine what the facts are. So you say X, he says Y. The court has to determine what the facts are. And in this case, since it is seeking injunctive relief, since it is a court of equity, the finder of fact is the judge. If this was a criminal case and he was entitled to a jury, and he in fact elected to have the jury, then the jury would be the finder of fact. The judge is always the determiner of what the law is. The jury decides what the facts are. If there is no jury, then the judge would decide what the facts are. So what the judge finds as facts is pretty hard to disturb those at appeal. It's generally speaking, a losing proposition to appeal findings of facts. And yes, the judge is biased because the judge just watched Lane Myers act like a dumbass for the hearing. The judge listened to the evidence that was presented, and the evidence and the actions of Lane Myers biased the judge. Like if you think that's a gotcha, no, that's the point of the trial. The point of a trial is to bias the judge. She was better at it than Lane was. She biased the judge against Lane. Lane was not able to bias the judge against her. Do you see how that works? You probably don't because you're dumb.
I find that there are a series of acts. I think the first voice from the defendant qualifies. The YouTube videos qualify. I believe the defendant was encouraging third parties directly or indirectly to make calls.
So the judge, so his opinion, because he is the finder of fact, is the fact. Legally speaking, it's the fact. Now, juries and judges can make findings of fact that aren't, in fact, true. So if you're saying, like, as far as reality is concerned, what the actual truth is, no, the judge doesn't determine that. But the judge determines what the facts are for the purpose of coming to a judgment. Yeah, this is fucking stupid.
With another act. I referenced the statute earlier, ARS 13-29.1.
Doesn't apply.
It doesn't apply. That is a correct statement of law, except you should have made that argument earlier and more concisely.
Please stop interrupting. I will give you a chance.
Quit gaslighting the people, sir.
I will give you a chance to make the record.
He's not gaslighting the people. He's stating the decision that he made about the facts and the law. That's not gaslighting. It's his job at the end of it to say, here's what I find and here's how I found it. He's creating a record for you dumb fuck, to appeal. His findings of fact and his findings of law are literally what you would take to use to appeal. And you're trying to get him to stop. No, you let him fucking talk so that you develop the record for the appeal. It's for the appeal. He doesn't even know. Like, the whole point of this is to develop the record for the appeal. Because you appeal the findings of fact and you appeal the findings of law. And the judge is telling you his findings of fact and findings of law. Moron.
The statute talks about contacting or causing a communication. I believe in finding that the defendant has caused.
So, my retarded friend, who apparently I can't time you out, and I don't want to ban you, so I won't. So don't think that I'm threatening you with banning. But let me just suggest to you that your sensibilities are not everybody's. Most people don't really care that I say retarded things are retarded. And I have actually got clients who've retained me specifically because of the videos that I put out. So, no. My legal colleagues, I don't really fucking care about their opinions of me. I'll be perfectly honest with you. Although I have had legal colleagues who have watched my videos, like opposing counsel Hey, aren't you that guy from YouTube? And yeah, and believe it or not, like I have attorneys in here, Adam Fox, Paul Carroll, like real attorneys, licensed to practice. I know who these people are, and they're licensed to practice. They don't seem to have a problem with me, Dolores. I think you're the one misreading the situation. I'm saying this to help you out because you're dumb and you're retarded. And most people need to be told they're dumb and retarded so that they can stop being dumb and retarded. Now, if you're too dumb and too retarded, you may think, well, you're just attacking me. I am actually smart because Dunning-Kruger told me so. And I refuse to change based on you showing me some things that should be pretty self-evident. Like there are other attorneys in here who are agreeing with me and not with you. So you could learn from this, or you could double down. Now you've chosen to double down, and that's fine. But that says more about you than it does about me. It shows that you're the retarded one, and I'm not. Because I've literally gotten clients from here, and I've also had attorneys. Attorneys tend to agree with me. So there you go. So good luck. You care about my results? Well, no. See, you need me to be a hugger. And actually I did. A client hugged me. When was that? When was that hearing? Was that Thursday or Friday? It was Friday. I had a hug. Client gave me a hug. She was so happy with my results. I got a hug. How many times do your clients hug you? Okay. How many times do your clients hug you?
That's going to get overturned on appeal.
Explicitly encouraging them to contact her.
But see, you have to let the judge develop his findings of fact and findings of law, because those are what you appeal. Well, you could also appeal like objections that were overruled or whatever, but good luck on that. Because I mean, showing that those would have a significant outcome on the case, especially after he says that he finds you to be not credible and he finds her to be credible. Well, your mileage may vary, but good luck.
Cases that support that are SEDA, 2012 Westlaw.
So again, no. See, you're dumb. So I address things publicly on videos if I believe that other people are making the same general errors. And it wasn't just her. There was a few other people like that MTN mover or whatever. There's a few other people who are doing it. So if she's having this opinion, then other people might be having the opinion. And so what I do is I present the evidence and then I move along. So I'm done with her. We're good. And I also said I was done with you. So yeah.
2097.
So this must be added in the aftermath by public service. But yes, it was inappropriate for her to cite this case, but she's pro per. So what are you going to do? And it was also improper for the court to make the decision based on this case. But let's actually hear it. Hopefully we can catch it without Lane Myers talking over it.
That's going to get overturned on appeal.
Explicitly encouraging them to contact her. Cases that support that are SEDA, 2012 Westlaw 209751, paragraph 25. That case talks about a defendant who made calls to building employees and others with the
Calls, not call.
With the intent to
Calls, not call.
Explicitly encouraging them to contact her. Cases that support that are SEDA. Support that are SEDA.
STEVA. I thought he had cited the other case. Select courts, Arizona. Let's try that again.
Cases that support that are SEDA.
Am I hearing that wrong? Is it STVEA? STVEA? If anybody caught that citation, please type it out for me.
That support that we select are versus Stava, SEVDA.
Stava, STAVA? STEVA? It keeps adding shit to it, my search. I didn't search Stava versus Colvin. STEVA doesn't work. STEBA? STEBA? Nope. Let's try it again, folks.
That support that we select are versus Stava, SEVDA.
SEVEA. Let's try SEVEA. SEV.
That support that we select are versus Stava, SEVDA.
SEVEA. One more time.
That support that we select are versus Stava, SEVDA.
SCEVA? Nah, I don't know what he's citing there. What else we have here? DNEA. Maricopa. SEBBA. SEBBA. So this, okay. So this is not citable. That's a problem. And this is also referring to criminal laws. Criminal laws. Yeah. So again, I think this could be an error of the court. So that'd be interesting. That'd be interesting. So yeah, I mean, there are grounds for appeal. I just don't know. I just don't think that the issue, like if the appeals court finds that he used the wrong law, that the judge used the wrong law, and it comes back, I think the judge will still make the same decision. So
2012 Westlaw 209751, paragraph 25, actually talks about a defendant who made calls to building employees and others with the
Calls, not call.
with the intent to
Calls, not call.
serve.
So this is the thing, and the SEBA was making these calls to the building managers and security guard. So it was directed. So for the purposes of the criminal statute, it was directed at SEBA because the victim was making calls, or because the alleged, or the defendant was making calls to third parties, directing them essentially to harass the alleged victim. So, but again, I don't think this is an appropriate case to cite because it's using a different statute with different elements.
Interrupt me again, I'm going to ask you to leave.
I'm about to leave voluntarily.
You're not going to get a chance to make the record.
You're getting overturned on appeal whether I do or not.
Maybe not. I mean, he needs to make his record. So maybe not. I mean, that's what the appeals court looks at. The appeals court looks at the record.
You've been warned.
You've been warned you're getting sued too.
All right, I'm asking you to leave.
Thank you.
You're getting sued too. Dumb.
Thank you.
So that'll be posted on, somebody will mail it to me or something?
We're going to give it to you right now.
Cool,
Just
thank
sign
you.
right here for me saying that you got it. Sign this right here, saying that you got
Right
it.
here? Cool. You guys can talk amongst
Do you want
yourselves.
Do you want your disc, your little flash drive back?
I thought it was on the record for appeal.
Hold on, let me check. Maybe I misunderstood. Oh,
Here's your exhibit.
sign here. and-
Why is my exhibit not being turned in for the appeal? That's what we turned exhibits in, for the record for appeal.
You've lost your chance to be here. You keep interrupting me.
That doesn't mean I lost my chance to put an exhibit on the record.
If you want to go outside
Just
and
sign
come
this
back
right
in
here.
5 minutes after you calm down and follow the rules, I'll let you. But right now, you're not following the rules.
Oh, my sweet summer child. I don't know how to explain this to you using smaller words. I really don't. So the record is the facts and the law. The record is the facts and the law. The record is the facts and the law. You don't get to go to the Court of Appeals and retry the case. The Court of Appeals is going to use the facts and the law, which together, by their superpowers, form the record.
You need to leave.
It's your choice.
Should you want me to leave my stuff here?
You want to come back in 5 minutes?
That's the judge is being so nice. You want to come back in 5 minutes? You go back in 5 minutes. I'm giving you the option to come back in here and make your record, i.e., to place whatever objections necessary on the record that might be useful to you to prevail at a appeal. So the record is not truth. I thought we had gone over this. I really did. I really thought we'd gone over this. This is the last time. So Simba, I need you to pull your head out of your ass and pay attention. Okay? I need you to pull your head out of your ass and pay attention. The judge makes findings of fact. Those findings of fact may be true or they may be false. But the judge says, these are the facts as I understand them. And it's his findings of fact that you appeal. It's his findings of law. This is the law as I understand it. Is that the true law? No, it's the judge's understanding of the law. Can judges get the facts wrong? Absolutely. They do it all the time. And that's the point of having a good attorney. A good attorney is going to take the steps necessary to make sure that the court understands your facts and that the court accepts your version of the law. Because you get one shot at trial. And one of the hardest things to do, one of the absolute hardest things to do, is to appeal a finding of fact. Basically, the Court of Appeals is supposed to look at it and accept everything, every finding of fact that the lower court made as true. That's what the Court of Appeal is supposed to do. The very rare exception is if they find that the fact found by the lower court is basically not supported by any evidence. And if the Court of Appeals finds that a finding of fact was not supported by any evidence, then it can get overturned. But it is very uncommon. It is very uncommon that findings of fact get overturned by the Court of Appeals. Now, if the judge gets the law wrong, and to answer your question about the law has versions, absolutely, in a lot of ways. But your question was vague, so I don't even fucking know how to answer it. But assuming you're responding to me, there's my version of law. This is how I want you to read the law. Opposing counsel will have his version of the law, how he wants you to read it. And then the judge will have his understanding of the law. And the judge will may be swayed by your arguments that the law should be read this way. He may be swayed by the opposing counsel's version that the law should be read this way, or he may be persuaded by neither parties. And then if he uses a version that you think you can appeal, if you think the judge got it wrong, then the Court of Appeals is going to tell you how they think it should be read, how they read it, how they understand it. And they might get it wrong. And then the Supreme Court might take it and be like, you know what? Absolutely not. This is the way it's supposed to be read. So literally everybody could have gotten it wrong. But the only way you know is if the highest court to have looked at it says it means this or it means that. That's how we know. And so the ultimate arbiter is the Supreme Court, the state Supreme Court for state issues, the federal Supreme Court for federal issues. But yeah, everybody can get it wrong. And that's what I mean. That's what I mean. The issues of like these things, like, well, I'm done beating that horse to death. Absolutely. Absolutely. The judge is not limited to what the two sides argued. The judge can have his own completely different understanding of the law, and he can base it on, and that happens pretty regularly. I mean, as a practicing attorney, that happens pretty regularly. You bring case X that you think supports the way you want it read. They bring case Y that supports the way they want it read. And the judge says, actually, I like case Z that says it the way I want it read. That happens all the time. And if you think this is unreasonable, just remember that the point of the United States Supreme Court, one of the ways that they determine whether or not they're going to take a case is if there's a circuit split. Like if the first, second, and third circuits look at this law in this way, and the fourth, fifth, and sixth circuits look at it that way, then the Supreme Court is more likely to take the case to resolve that circuit split. Well, I don't know how you were taught law is, but you might be figuring out that my version of reality actually comports with reality. No, it's not what you were saying earlier. And if you were trying to say that, well, you're retarded and you should learn how to use English. So, yeah, Yeah, who taught her the law, right? Exactly. All right, back to this.
That needs to be, yeah, sure.
All right, go outside.
Turn
calm
off
down.
your.
I don't need to turn off my recording.
Yeah, it has to be on your person.
Then I'm not, then I'm just leaving.
Oof. It's a little tantrum that I'm just leaving. Well, that was a bad mistake. And this is why I don't know if he has an appeal.
Sign
Here.
If this isn't on the record, you're getting sued. You know that. So I'm going to leave it right there.
You're getting sued. Well, why? Because the judge gave you the opportunity to come back in 5 minutes and you decided to leave anyway? I mean, you're going to sue it like, good luck. Good luck.
You don't get to tell me I don't get to put an exhibit in because I hurt your feelings, Your Honor.
He didn't tell you that. You're just dumb and you don't understand things.
See you in court, Your Honor.
Ooh, see you in court, Your Honor. You're in court right now, motherfucker. You're in court right now. And yeah, you're seeing him in court. Guess, like, oh, Lord, please don't throw me in that briar patch.
I'll be filing an appeal when I walk downstairs. Notice of appeal will be filed when I get downstairs and the special action.
Woo, notice of appeal will be filed when I get downstairs. Woo, woo, and a special action. Woo.
Against you. So is that getting in, or I need to put a special action on that too?
I think you should put the special action on that, big boy.
Please leave, sir. Is that being taken into evidence or not?
The judge told you to leave. You're not leaving. You're actually in contempt of an order right now.
You are violating a court order right now by not leaving.
Hold me in contempt, bro. I dare you.
By calling me bro is very disrespectful. By cussing at me and throwing things at my staff. All right, if we can have the minute entry note that the defendant has left. If the minute entry can note that on his way out, the defendant repeatedly cussed at the judge.
Guess what the judge is doing here? Guess what the judge is doing here? The judge is further establishing the record. I mean,
if the minute entry could note that the defendant, what is that called? A flash drive towards my staff.
oh.
It's a minute entry could note that the court repeatedly ordered the defendant to leave after warning him that he wasn't following the rules. He failed to do so, continuing to violate a court order. I'll now continue to explain my thought process. I'll add to the credibility determinations the defendant's conduct on his way out lends to my credibility determination about him that I do not find him credible at all.
That's rough. I mean, how is he going to argue that the court should have accepted his version of the facts with all of these findings that are supported by his own words and actions, that he's not credible?
The other case that supports my application of ARS 13-2921, I think is State versus Snyder. That is.
He's applying 3921 State versus Snyder. I don't understand how or why he's able to do that.
It's 2024 Westlaw 342301, and specifically paragraph 16.
He keeps citing criminal harassment cases, and there's a different, like 2921 has its own definition of harassment that's different than 12-1809. So I think this is a fundamental error of the court. Now, if Myers appeals and it goes up, it'll just come back to this court to make rulings that are in line with 1809. But it's still an appealable issue that he might be able to win on an appeal. But I don't think it will that it'll really help him in the long run. So like if the Snyder or whoever, if somebody appealed the Court of Appeals decision, they would be able to cite that Court of Appeals decision, even though it's unpublished. So if Jeffrey Joseph Snyder, the appellant, lost the appeal and he filed a petition for writ of certiorari with the Arizona Supreme Court, then he would be able to cite this particular case. And there might be a few other places where you can cite it. Like if you want to cite it for purposes of res judicata, that's my understanding of when you'd be able to cite it. Again, I'm not an Arizona attorney, but that's generally speaking when you could cite non-citable things.
That case talks about the defendant posting videos, and talks about several people contacting the plaintiff about.
It says, are they overlapping definitions? Maybe. I haven't seen a case that says they are. Again, there's a ARS 12-1809 is this one here, and ARS 13-2921, which is this one right here. Now, share this tab instead. So for the 12-1809, harassment means this. Means either of the following. So sexual violence is defined in 23-371, or a series of acts over any period of time that is directed at a specific person and that would cause a reasonable person to be seriously annoyed or alarmed, annoyed, harassed, and the conduct, in fact, seriously alarms, annoys, harasses the person, and serves no legitimate purpose. And the case law, the LaFaro case law, says that directed at a specific person means that it has to be directed at that specific person. The Seba case, which the court used for the proposition that it doesn't have to be directed at a specific person, is different than the LaFaro case. LaFaro says it has to be actually directed at the alleged victim. So that's the civil harassment. Now, harassment as far as the criminal harassment is this definition. So they have to knowingly, which is a state of mind, and repeatedly commit an act or acts that harasses the other person, or the person knowingly, again, that's a state of mind, mens rea, commits one or more of the following acts in a manner that harasses, contacts, or causes a communication with another person by verbal, electronic, mechanical, telegraphic, telephonic, or written means. So they are different. Now, one of the ways that they're really different is, again, that definition in LaFaro versus the definition in Seba over what constitutes directed at. So it might not be in the statute itself, but it might be in the various cases that figure out what the statute means, if that makes sense.
About the videos posted by the defendant, and talks about holding the defendant responsible for the resulting communication of those third parties not being so extraordinary that it would be unfair.
No, it doesn't have to be threatening. Threatening is not in either one of them. And as far as the contact the victim directly, as far as the criminal statute is required, it doesn't have to be contacting the victim directly. It can be contacted through third parties. That's what Seba stands for, the proposition of. And because they arrived at it in Seba, they could arrive at it again. And in the other case that they cited, where he posted on social media, I forget the name of it. So as far as criminal is concerned, no, it does not have to be that way. And also, they're criminalizing conduct, not speech. And to throw the videos out under fruit of a poisonous tree. No, so the fruit of the poisonous tree doctrine applies if they get evidence in violation of your Fourth Amendment or your Fifth Amendment rights. So if they unlawfully searched his computer and they find videos without a warrant and without probable cause, yada yada, then that could be suppressed under the fruit of the poisonous tree doctrine. Again, you're using words like that just don't fucking make any sense together. But since he actually published those videos, they don't violate any Fourth Amendment rights by watching YouTube. It's available to the public. So no, you still show that you don't understand shit from fuck though.
So I think that case supports my factual findings.
Are DV cases considered quasi-criminal? In California, I can't speak for every state. In California, there is criminal domestic violence and there is your standard civil domestic violence. So no. In California, the only quasi-criminal thing kind of related would be contempt. Contempt is generally speaking quasi-criminal because while it is a civil action, it's brought in civil court. In theory, you could do time, so it's quasi-criminal.
I do think that all of these acts that I've mentioned were directed at the plaintiff. I can totally understand why she is alarmed, scared. I think
so. The court found that all the actions were directed at the plaintiff. So that's a finding of fact. That's a finding of fact. Well, maybe it's a finding of law because he cited the case. I don't know. I would argue, if I was Lane, I would argue that that's a finding of law based on inappropriate case law. If it goes up on appeal, her attorney or her will probably argue that it was a finding of fact. Because again, it's a lot harder to overturn a finding of fact on appeal than a finding of law.
not only a reasonable person would be, but I think almost any person would be. I think it'd be unreasonable not to do. I'm finding that there's no legitimate purpose for any of these contracts. And in fact,
I think that's a finding of fact as well.
I'm specifically finding that I think the defendant's purpose is specifically designed to harass and bug.
That sounds like a finding of facts. That's a problem. That's a real problem for Lane.
And annoy. And I think his conduct during this hearing has confirmed that. That said, the order that I've sent, and I'll make sure that the plaintiff gets a copy of the order that I've signed, does affirm that the defendant is to have no contact with the plaintiff, not to go near a protected location. The other orders is what I've changed. The defendant must have no direct or indirect contact with plaintiff. Direct
or indirect. Indirect would be using third parties to make the contact.
Through any form of social media. That was basically in there before. The defendant must not post or place plaintiff's contact information, including her work information, on any social media platform. Defendant must not, through social media or otherwise, directly or indirectly encourage third parties to contact plaintiff or to go to a protected location. What I'm trying to do there is balance the defendant's constitutional rights with the right of this plaintiff not to be harassed. I think I've done that. I tried to do that. We'll just note that I was going to give the defendant.
All right. This is also, let me help you out here. An insult is just an insult. So Dolores, if I said you're stupid and weird, that's an insult. It may or may not be true. It doesn't have to be true. It doesn't have to be false. It's just an insult. If I said you're wrong because you're stupid and weird, well, that would be an ad hominem. Obviously, Dolores can't be right. Obviously, she must be wrong because she's stupid and weird. That's an ad hominem. But Dolores, you're dumb and you're wrong. And the reason why you're dumb and you're wrong is because X, Y, and Z. That's an insult. That's just a preface for an argument. I hope that makes sense. It probably won't because you're really not very smart. And you should probably shut the fuck up because everybody's realizing how stupid you are. So, you know, and also saying that you're just making ad hominems when you're not actually, when the other person isn't making that homonym, that's probably a fallacious argument to make as well. Because you're suggesting that no argument was made, only ad hominem, when it wasn't an ad hominem, it was an argument that was prefaced by an insult. And see, you're still fucking dumb and retarded. Like some people, see, the problem is that some people you're just not able, some people can't be taught. They're just not smart enough. Just not smart enough. But the dumber they are, and it's weird, like the dumber they are, the more they feel like people need to actually hear them. The dumber they are, the more they talk. Like Chris, for example, the dumber he is, the more he talks. It's insane to me. Like the dumber you are, the more you should shut the fuck up and listen. The smarter you are, the more you should talk to spread your spread your knowledge. The dumber you are, you should just shut the fuck up and listen. Maybe you'll learn something. Maybe you'll stop being so dumb. Probably not, but you're never going to learn if you keep fucking running your fucking pie hole. You're going to keep running the pie hole. I didn't know they do. But I say, if you are angry with someone, you're subject to judgment. If you call somebody, you're in danger of being brought before the court. Well, so, I mean, it depends. It depends. It depends. There are elements to these various things. And so just calling someone an idiot doesn't expose you. I mean, there's all sorts of things that have to be filled. There's elements that have to be met. Jesus fucking Christ.
An opportunity to hear those restrictions and convince me if I should do something else, put different wording in there. He has chosen not to participate anymore in the hearing. So to the extent he had any insight on that, we don't have it. We don't have the benefit of it.
So what he lost there is he lost the ability to suggest to the court that the particular order the court is making might be a violation of his First Amendment rights. It might be overbroad, it might be vague, etc. So this is why he should have stayed.
Ms. Walker, anything I'm missing, more of a record or findings that you want me to make?
One thing that, Your Honor, I have wondered about, just that goes to my fear of Mr. Myers, is that I don't believe he's been ordered to not have any weapons. I don't know if that's something that can be considered, but that's something that was not part of the original injunction against harassment.
I didn't hear any testimony or evidence about guns or flashing guns or anything like that. I'm reluctant to do that without that sort of.
Okay, I understand.
I hope it doesn't happen, but if it does happen, feel free to come back and ask for a modification.
Okay, thank you, ma'am.
Anything else that you want to do? Any other findings that you think I should be making if we anticipate the appellate court is wondering?
I'm very happy that the court did not take the opportunity to restrict his right to carry firearms. Again, I'm not hoping for a bad outcome for Lane. I'm just expecting a bad outcome for him.
What I did and why?
Your Honor, I do have a question about the current videos that are still displayed on Mr. Myers' YouTube channel that violate this. I understand that things that are outside of the protect order are not considered, but he has violated this probably more than a dozen times with additional social media content. Is there any sort of consideration for him to be required to take those videos down that do display my contact information? Because unfortunately, they do continue to encourage people to reach out to me as recently as today to harass me.
I'm thinking.
No, because it wasn't in front of the court.
Of course. Thank you.
It must be a first. I did know that I have the authority to do things that happened already from a First Amendment standpoint. I'm by no means a First Amendment scholar, or although I did dabble in it, I'm interested in it. So I don't feel comfortable doing that in past tense as opposed to going forward.
I understand. Thank you for considering.
Why did she bring it up? She brought it up because she was hoping the court would grant it. You get 0% of the things you don't ask for, and you get some percentage of the things you do ask for. So the general rule of thumb is to ask for it. As an attorney, if my client wants something, I generally ask for it, even if I don't believe that my client will get it. Even if I think the court will probably say no, you still ask for it, because there's always a chance. Courts make mistakes all the time. You just ask for it.
I wish I could do more. for you. I apologize.
You have nothing to be sorry for. Thank you so much for giving me today.
And if you think there's more I can do from a constitutional standpoint, file something, file a brief, give me the cases, ask for modification, and I will listen with both ears.
Thank you, Your Honor.
Thanks, everybody. Have a good one.
Is there a higher bar to reach harassment against a public official? Well, in Arizona, it does not appear to be that way. Although the spectrum of legitimate purpose is quite a bit bigger for public officials. Like I said, if you disagree with what a private citizen does, and then you make a whole bunch of videos about it, that might be harassment. If you disagree with what a judge does as a judge, and you make a whole bunch of videos about it, that's probably protected speech. It's criticism. The whole Houston v. Hill thing, public officials have to be able to accept more criticism. So on the one hand, yes, I think there would be, it would be easier, I think, to justify as legitimate things that are said about a public official than are said about a private individual, if that helps. But again, I think that this was directed at her as the reason why it was directed at her, I agree with the court. It was directed at her because of her being married to the prosecutor. I still don't think this has anything to do with her job at the university. I haven't seen anything even remotely that would suggest to me that but for her being an employee of the University of Arizona Law School, that Lane wouldn't have said anything about her. I think he would have. If she'd been a housewife, I think he would have been doing what he could do to get at the prosecutor through her. It might have been harder to find her phone number, but I don't see why he wouldn't have done it. Again, you back up his claims. I back up whose claims? I don't know what the fuck you're on about. Yes, that's how they sound. It's fucking retarded. It's fucking retarded. All right, let's finish this off.
We're out here today to ensure.
So I guess that's the end of it. I was kind of hoping to get to a couple others today, but we're 4.5 hours into it. So I'm probably just going to call it here. I hope you can see, like, if you actually watch this, if you went through this, you could see where there were some real fucking bad shit that he did. He screwed the pooch. He shit the bed. He fucked himself. He made admissions that are just terrible for him that could, in theory, be used in his criminal case to just fuck him in the asshole. And well, then get the fuck out, dude. Like, no one will notice that you're gone. Bye-bye. Ugh, fuck. Anyway, so that's all I got for you today. Thank you so much for watching, and have a great day. Enjoy your Cesar Chavez day.